Politics in the United States of America. The left has gotten really left, and the right has gotten really right. Everyone's towing the line, and we're getting nowhere. Fast. This is the Rational American. The Rational American. Common sense has gone out the window, and our passion is to open eyes in hopes that people will take a rational look at what America is actually becoming. Put your feelings aside and let's get real. This is the Rational American, and this is your host, Steve Oatley.
Well, what's going on, everybody? Welcome. It is Monday morning, 9 o'clock in the morning, and I know most of you guys are like, wait, Steve, the trial's not starting till 9:30, and I figured I would talk for a little bit because I haven't done an episode of The Rational American in a while, so I figured I would talk for a little bit. I've been here since 5 o'clock in the morning, finally finished packing all the coffee and sending out the first 20 orders with Gratis Coffee, Gratis Cafe, and now I have to convert all the Pure Truth orders. Yeah, so I'll be busy a lot. I worked all day yesterday. I worked all day today, or all morning so far. Anyway, the trial is going to begin in a little bit, but I wanted to talk about some things that just simply don't make sense, right? It's hard to rationalize some of the things that are happening right now. Like, let's take yesterday, for example, in Eugene, Oregon. A group of counter-protesters showed up to protest it wasn't a trans, it was a drag show where apparently an 11-year-old was the main person, 11-year-old girl who wants to dress in drag and then dance around seductively, which is in itself incredibly disturbing, right? They call it art. It's not art. It's incredibly disturbing. But so this group of counter-protesters, preachers, just patriotic people that care about our country and are trying to keep, children. They go out there and protest. There's been a lot of chatter about it for the past couple of days. So obviously Antifa was in full force there, Antifa faction, whatever you want to call them, the morons that dress in black bloc hiding their face because they're ashamed of themselves. But they were out there yesterday, and there's a lot of, I won't say conducive conversation, but in all reality, there was no violence, in the beginning. There was no violence at all. And people were having conversations back and forth and trying to make an understanding of what was going on. Now, you had some of these people that claimed to be on the side of, I don't even know what you'd call it. Understanding is what they kept saying. And so they were there to protect the trans people who want to see little children dance, which it just in itself is concerning, to say the least. But you had them, and it was really weird because, like, for example, Quincy, the black conservative preacher, was out there live streaming. One of the opposing people, this guy was definitely a 60-year-old hippie or something, but he's out there chastising, Quincy's religion and everything, and then calls him a monkey. And so Quincy, of course, started bringing light to that, and Antifa actually surrounded that guy and kicked that guy out, saying he was not being an ally, blah, blah, blah. Listen, what's funny about this is Ford Fisher, and many of you guys know who he is. He's News to Share on Twitter. He runs like an independent news organization, and they market their footage out to news organizations and sell their footage. That's what they do. They claim to be independent. Well, they hired someone named Mason Lake, or they at least purchased the footage from Mason Lake. If you covered the riots of 2020 in Portland, Oregon, you know that Mason Lake is not a neutral journalist. But Mason Lake sent in footage of part of the confrontation that happened after the group left. And this is something I don't understand in the city of Portland and Oregon in general, on why when people show up, here's the thing, like this group of patriots showed up heavily armed, wearing bulletproof vests. Some were carrying long arms, some had pistols, some had batons or bear mace or pepper ball guns and all that because they were looking for a fight. That's what they went out there to do. And then there was another faction that was there trying to preach. There was a lot of religious people trying to preach to these people that are there to watch children dance on a stage. And then there were other people that were just definitely concerned, right? Concerned about the well-being of the children and all that stuff, because there were children there, which is disgusting. There was no violence. I watched the entire live stream as I was sitting here packing coffee. There was no violence whatsoever until this group of armed patriots decided to leave. Now, you may be saying to yourself, especially if you follow Ford Fisher or anything like that, you probably are assuming that the patriots were the first ones that struck out and started attacking these anti-fascist scum, right? And maybe rightfully so if that was the case, but that's not the case. In fact, as the patriotic armed group, and I have a hard time calling it patriotic, because you're not going out there to advocate for something positive if you are heavily armed. Do you know what I mean? If you're heavily armed, if you're wearing body armor, if you're bringing mace, what you're doing is looking for a confrontation. It's like people that open carry. I've never been a big fan of that, but if you're going to go someplace armed, why not just conceal it so you're good? But so I'm watching this live, right? And I'm watching it live, and I'm pissed off at for one, as soon as the patriotic, the heavily armed people, and make no mistake, Antifa was armed too. There were Antifa black bloc people with long guns and all that stuff too. But as the patriots decided to leave, they just turned and walked away. And when they turned and walked away, of course, then all the anti-fascist scumbags started chasing them and throwing bottles and all that stuff. But the very first attack, the very first fist thrown, or the very first act of physical aggression was on an elderly woman. The anti-fascist scumbags pepper sprayed her in the face. I watched it live. And if you watch Quincy's footage, you can see Mason Lake, that photographer who sold the footage to Ford Fisher. You can see him there. He's capturing that whole thing. He captures her on the ground. And then finally the Patriots then come back, and they're acting all tough and stuff to try to keep everybody away, rightfully so. They weren't pepper spraying. They weren't doing anything except trying to protect this elderly woman who was now on the ground, pepper sprayed in the face. So guess what happened then? They get her up. Quincy's saying, we got to go, we got to go, we got to go. They get her up. Everyone starts walking away. And then a homeless guy is pushed from behind and smacks his head against the ground by Antifa again. And then and this is how you could tell who really gives a shit about humanity, right? Because all the anti-fascist people started high-fiving and they're cheering on, blah, 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 because they assumed this guy was a patriot when in fact he was just some homeless dude that happened to be in the area. And then guess what ends up happening? The Patriots then come back again, and they're rendering medical aid, and they're working together with some of these anti-fascist scumholes. And then, an ambulance is called and all that, but the ambulance doesn't come by the time the feed cuts out because, well, the ambulance isn't going to go down there while there's these two feuding groups of morons. Or not, they're not both morons, but you know what I'm saying. And so the homeless guy is hurt. He's laying down on the ground. There's a bunch of people around him. All these anti-fascist people are yelling at the Patriots to get away. They don't want to get away because this guy is harmed by them. They don't want to leave him there to get further attack. And look at the track record so far. The anti-fascists attacked a woman, an elderly woman, pepper spraying her in the face. They attacked a homeless man, possibly causing a major head injury. And so what are they supposed to do? Well, they finally get their shit together. And they decide they're going to leave that guy there. He's being helped by the Antifa medics. And so they start to walk away. As they're walking away, rocks and bottles are being tossed at them, consistently. And I watched this live. Nobody can deny it if you actually watch the video live. But then guess what happened? At that point, the Patriots decided to fire back. They used, pepper spray. They used mace. They used pepper ball guns and all that stuff to try to stop themselves getting attacked. That clip of the Patriots pepper spraying people and doing that is the only clip you're going to see out on social media now until Quincy takes his footage and puts it out, until the other people that had all the GoPros take their footage and put it out. because you're not going to see it, because Mason Lake, a leftist leaning journalist, and Ford Fisher. And I got to say this to Ford Fisher, because I tweeted at him last night. He's not being honest. He's not showing the whole thing. Mason Lake was there. You could see him in Quincy's footage. When you blindly share out edited footage of a confrontation, right? Just edited footage where you're not showing the whole thing, you are spinning a narrative. And if you truly want to be independent, then don't spin that narrative. Wait for all the evidence. Or when someone calls you out on it, don't just ignore the comments, because I know you see them. Don't try to be neutral. Don't try to do any of that, because you're not. If you're only pushing one agenda, you're not neutral. And it pisses me off. It pisses me off because here's the thing. Some of the people on the and I don't want to call everybody patriots, because I'll be honest, people that go out there just looking to beat the shit out of people it's not patriotic. It's not the American way. It's just not patriotic. But for simplicity, I'm calling one group patriots and I'm calling the other group anti-fascist, instead of trying to figure out what pronouns to use the trans people, because some of them are trans, some are not, some are blah, blah, blah. And there was this one girl with pink hair with weird eyes, and I don't know why, but she was always in the middle of the focus. That was on the Antifa side. Anyway, it ticked me off, because there was some good conversation. You had some people that were religious that were having good conversation with people on the opposite side, talking about why they're out there. It's always going to be overshadowed by this senseless violence, because these Antifa people, and I'll be honest, the people on the left that are radical, morons that hide behind, cotton ski masks and think that they're big and tough while they weigh like 110 pounds, including the body armor. You have those people that are their goal is not to have any conversation. They just want to call everybody fascist while exhibiting fascist behavior themselves. But they don't want to have a conversation. They don't want to even provide their context, or their viewpoints on something. They just say it's either this or nothing, right? And then you also have people on the right that do the same thing, because I saw that yesterday as well, where people are using slurs, to describe people. I saw racism from both sides. I saw sexism and homophobism or whatever from both sides. Literally, some of the people that were championing trans rights were literally being homophobic towards other people. It was the weirdest thing when you actually sit down and try to look at it from a neutral perspective, listening to it. It was the weirdest thing. But then to see the violence get called out on social media as right violence, that's not true. It's not true at all. And you know what? And that often happens with these two groups when they battle out in Portland and Washington and Oregon in general. That's often what happens. The left attacks the right defends themselves, and then the right is framed as this fringe, far right, weird group. And I've never understood it. But then yesterday I was watching it, and I'm thinking to myself, I'm like, it's not surprising that patriotic groups, especially in the West, in the Pacific Northwest, don't get a lot of turnout, right? Because what you have is you don't have groups of just like patriotic people. No, instead what you have is this violent, and that's what I saw. And I'm someone on the right. But when you have a group that goes out there and the only thing they want to do, or the only position they're imposing, is that they want to cause violence, then you're going to get violence. Violent rhetoric begets violence. That's what it does. That's what it causes. And I'll be honest, I watched it and I saw a lot of good conversation with a lot of people. You know what I mean? And then I saw just stupid boneheaded insults going back and forth. But there was a lot of positive conversation. We're not going to see clips of that positive conversation because it doesn't fit any narrative. It doesn't fit the right narrative that the left are all wingnuts, and it doesn't fit the left narrative that the right are all wingnuts. So that's not the part you're going to see. You're only going to see what's being framed as the right attacks peaceful trans protesters, because that's the narrative that they want. That is the narrative that they want to present to you. And it pisses me off. It pisses me off the most that Ford Fisher didn't do even the slightest bit of information, or research on something, or at least the person that he's hiring to do, documentary work. You can see that someone has a clear bias the second you go to his Twitter page, that Mason Lake photo or whatever. You can see a complete and utter bias right from the very get-go. I don't know. It just really offends me. I guess is the easiest way to say it. To see when people are putting out, fake news. You know what I mean? And that's what you're doing. If you only put out one clip that tells a particular story, especially when it's not that way. I know Quincy has footage, so he has to go and put out all that footage. Here, Quincy is independent. He's only getting paid by going out there and live stream. Mason Lake sold his videos to News to Share, and then News to Share takes the best clip that they think they can market out. They put a giant watermark on it, and they share it out to social media in hopes that someone's going to buy the videos. And I wouldn't be surprised if someone does buy that video and they play it on the news, and then they frame it again as patriots attacked peaceful left-wing activists, which is not the case. If you watched it yesterday, it's not the case. And it's very frustrating. It's getting very frustrating. And there was a lot of different events. There was one down in Southern California with AOC about early voting. And there's so much stuff that's going on in this country. The one thing that I think is really important to realize is President Biden yesterday did this interview. Remember the ultra beauty thing? I talked about that for a few minutes. And I said, there's a difference between just advocating for trans rights and versus promoting that to children, right? That's just my opinion. And I know many people will disagree, and that's fine. You're allowed to. We all have, different opinions about everything. That's a given. We know that. But the truth of the matter is that video that I watched the other day that I played on here, the Ultra Beauty, they did this podcast. It was like, two dudes that were identify as women that were talking about girlhood and saying they are experiencing girlhood as adult males dressed as females, which doesn't make, one of them literally had a beard, was dressed as a woman with a beard. That ticked me off a little bit and the reason is because I feel like that podcast, the way they were talking, that is geared toward adolescent males or adolescent females and telling them that it's okay to go out and do that kind of stuff. But if you say it's okay just to be a regular male or a regular female, then you're being some sort of sexist, right? I guarantee if there are they did podcasts about masculinity, and see, Andrew Tate's not a good representation of that, and they canceled him, and I almost said he was a representation. No, but are there any like famous people where they just talk about what it's like to be in a normal relationship, what it's like to grow up and just be happy with who you are? We don't have that. We have all these like fringe, on both sides. And you got to understand, to me, the right is doing more to push people towards that radical way of thinking because they hate in the vitriol for that. Do you know what I mean? So at least to me, it seems that if someone's already on the cusp of feeling, and I don't want to say weird, but feeling different, right? Let's say that. If someone's already on the cusp and you have one group that's out there saying, come on in, the water's fine. And then you got the other group saying, you're a fucking weirdo freak if you go that way. Of course, the right is literally pushing people towards the same thing that they're apparently fighting against, and which is crazy. But that ultra beauty thing that I talked about in length the other day, it pissed me off because I felt like that was geared towards adolescents. The way they were talking, it was talking about girlhood. I had a feeling like they're like, for the first time in my life, I can live my life as a girl. No, you can't. You're still a dude. And you're not even a little dude. You're a grown man that's dressing and acting like a teenager, a teenage girl, which is just odd to me. It's just very, very weird, because it just doesn't make sense, to have a grown man acting like a teenage girl. It doesn't make any sense. That person, because apparently this is an agenda that the left is trying to push down your throats. Like they are trying to just get it through and through, right? So the left has been pushing it out. They did an interview with President Biden the other day. And I didn't watch it, to be honest. I can't watch it because it was that same dude that's dressed as a girl that wants to experience girlhood. And he's interviewing President Biden. And she's like, for 72 days, I've been able to live my life as a female. And he's like, well, God willing, or something like that. How is that? My way of thinking right now is that they are definitely trying to push that ideology because what they are intending to do is to cause you, people that align with the right, to have a distaste or a hatred, or at least espouse that, because that seems to be what's going on. A lot of people on the right are attacking people that have those feelings, those whatever you want, those wants to be that way. A lot of people, instead of like counseling or educating people on stuff, the people on the right are just calling them freaks or do this or that, which you would think pushes them, right? Pushes them towards something. And it's confusing to me. It really, really is. You know, the more I talk about it, the more I don't understand it. But it's incredibly confusing to me, you know? And it makes me mad. Just makes me mad. So I wanted to start off and just talk a little bit about that. And I'll probably clip some of the segments of this show when I am just ranting and raving throughout, and then I'll put it out as a podcast later. The trial is supposedly beginning. However, this is just going to be preliminary stuff and I'm not grabbing long crimes. So I wait for the feeds that I use every day are the ones that I wait for. So I'm not going to pick up long crime and get copywritten or anything like that. But what I can do, they're all going to be starting here. They just haven't started yet. So see, like this one just kicked on, and this is the feed we use. But this is day 16. There's no audio yet. The jury was told to come in at 9 o'clock their time, so 10 o'clock Eastern. They are going to go through some stuff now. We have to wait and see, because these days are going to be different, because we heard he doesn't have any more witnesses from what I understand outside of his mom. Darrell Brooks does have his mother, who is supposed to be testifying, and I'm not quite sure if he actually finalized his subpoena. The state, who was assisting him and doing all his subpoenas, said they're not willing to subpoena his mom because he speaks to her all the time on the phone, almost daily. And so they were unwilling to participate in serving his mother. So if his mother doesn't come today, we'll have to wait and see what is going to happen. The judge yesterday prepped to have a very long, they were going to do a motions day, and then she has what I believe were 70 pages. She's anticipating it's going to take her a long time for jury instructions. They're going to read out all the charges to the jury. Then they're going to go through closing arguments. The closing arguments are likely not going to be today, and the jury is not going to be sequestered today. My guess is that closing arguments will be tomorrow. Depending on how today goes, closing arguments would be tomorrow, and the jury would be. I don't know if they're going to sequester them or allow them to go home, because they allowed them to go home with Rittenhouse too, didn't they? And my guess is that's what's going to happen. This jury is going to go home during the day. So hopefully, because I don't know what the conviction is going to look like. I talked about last week on whether or not that we're going to see some sort of whatever. I don't know why I'm not hearing any audio. They must not have turned on audio. Or it's because I'm not wearing headphones. Could that be
Johnson
it?
Versus Darrell Brooks, case number
Now
21
it just turned on, I
CF
know.
1848. May I have the appearances, please?
Morning, Judge Sue Upper, Leslie Basie, and Zach Witchell appearing for the state of Wisconsin.
Here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all my rights here this morning. All rights reserved.
All right, good morning to you as well. The records reflect the individual known to this court as Darrell Brooks is present in person in custody. However, he is wearing street clothes, a suit and tie, and a mask.
For the record, I don't consent to being called that name.
It is noted. All right, Mr. Brooks, just preliminarily, do you anticipate calling any additional witnesses today?
For the record, I don't consent to being called that name. And what was the question?
Do you anticipate calling any witnesses today?
I don't believe today.
Well, we are here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added is your mother, Dawn Woods. So I would expect that if she's going to testify, she would be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
Oh, I haven't looked. Let me look.
Actually, I just went to you and then one to the prosecution. Is the audio on?
It is. The audio's on. Do you know when you sent those?
Saturday. So that would have been the 22nd.
State receive anything through like the interoffice communication?
We have not. I just checked this morning to see if there's anything new. Nothing has been received at my office. And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state.
No objection?
From you, sir?
No objection. I definitely want those documents received if they obtain important information.
You said you forwarded them to a staff member on Saturday?
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
And those are 2 ICF forms?
Yep, one addressed to you directly and one addressed to the district attorney's office.
I'm sending that. I will send it with high importance and we'll see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
The topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
Right, what information make an offer of proof for me, sir?
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle, Officer Ryan Schultz. Question was asked of, did he know if there were any recalls on that vehicle? And I believe that a Brady claim should be visited because there were in fact recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled. And that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you will see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles. And in light of the fact that these vehicles were recalled because of this malfunctioning throttle body for I believe it's counts 1 through 73 to be dismissed.
All right, what's the response from the state, if any?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration, there are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls. So it's a moot issue.
I don't believe it's a moot issue. And I actually have, the report should be in the mailroom as we speak. I had everything sent over priority mail, the actual information about the class action lawsuit, the actual information about the recalls for those models, like I said, 2008 through 2010. Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this. seeing is how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And seeing this a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning. And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now, that you can readily view this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question, it was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action, because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because, again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email, it's one page with what you said. I have to turn my head, I gotta figure out how to flip it. So give me a second.
Okay. And just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm going to turn, because it's the only way I can read it. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother, and from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do, and presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness.
Your
Hold
Your
on.
Honor.
Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him and it was asking questions directly related to information contained in that report.
All right. Go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court. So I
understand that, sir, but your request is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record. Either through counsel.
It was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm telling you,
trust.
she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like a.
So that's my decision.
I object to that, Your Honor.
I understand. I've made my decision. I expect that you respect the decision, at least as we're not going to debate it further.
Yes.
I now have the ICF, the one for the state to be provided to the state. Madam Clerk, I just gave that to you. All right, so Mr. Brooks, in light of that.
I respectfully object, Your Honor, and request the legal reconsideration of your ruling, Your Honor.
It's denied. The request for reconsideration is denied. There's no legal basis for me to do that at this point.
I respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
I wouldn't be the one you would make that request to, sir. So I can't
For the record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact, Your Honor?
Any other requests, sir? I'd like to move on.
Based on what law?
There's no
or
legal
fact?
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion. So it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor. Can you show me how or where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding a fact.
Denied.
Under what law and fact?
I made an oral ruling, sir. There's no requirement I do so in writing.
So you're denying a legal, you're denying a motion for finding a fact.
I am.
So how do I know what you're doing is legal, Your Honor?
All right, Mr. Brooks, we're going to move forward. At this time, I want to.
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It
advisements,
doesn't
and I'd
seem
ask
like
that
you're.
you
I
stop
don't need
interrupting
your
me.
advice.
No, I have to
need
give you advisements, sir, regarding your right to testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify.
You don't need
Do you
to
have
go
a
through-
witness
you
to
don't
call,
need to go
sir?
through anything with me on record. You
Actually,
need to,
I do so,
actually,
sir.
you
That
don't.
is required by law.
Actually, you don't. You need to do your job as a public servant,
Mr. Brooks,
and honor the oath that you
I
took.
need to
Your
go through
Honor.
these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you
So
will be
you're holding me in
removed
contempt
to the next courtroom so that I can properly go through these advisements
And
without
I
being
still-
interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with all
I need
due
you
respect,
to
in Illinois
not
versus
interrupt me.
Allen, in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm
Allen.
not trying to have a debate.
You are
I'm merely
advised
trying
that
to
it
understand
continued.
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that I'm
I've said
forfeiting
that
my
multiple
right.
times.
You
I've
saying-
given you multiple
You're
opportunities to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
Mr. Brooks,
By
I'm not holding
removing
you
me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor.
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your
wants to disrupt these proceedings, even
That's
in
not
a
true.
mild manner tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
the standards
because
of
it
form and
doesn't.
civility, and one of the
Illinois doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear the
state
courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there. Again, I'll
It
make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit
Thank you.
agreement for something that
I knew I was muted. It didn't take long this morning. Didn't take long, did it? Did it? Unbelievable. Unbelievable. Let me tell you what. I don't care who you are out there. That's some crazy shit. So they're going to remove him, put him in a side courtroom where he's going to pretend that he can't hear for several minutes. They're going to get through a couple of things, at which time he will put his headphones on. He'll say, "Is she talking to me?" He will then repeat some stuff. She'll go back and forth. He'll then ask to come back into the courtroom, and he will have wasted another hour or so of the court's time. This is something that has repeatedly occurred during this trial. If you can't tell, that's how I know exactly what's going to happen, how it's going to happen. He's going to get there. Likely he's going to hold his Bible and read as she talks, because then she's got to, as soon as he's in the courtroom, they're going to go on record again. She's going to describe having to remove him, place him on the other room. She's going to say, "I've confirmed with court staff and bailiffs that he can hear me," to which, and we'll hear an echo too of her audio fed back to him. So we know as well here at home that the audio works. And yeah, they're going to go back and forth. I didn't hear whether or not he was calling his mom, because that's what was supposed to be happening. is he was supposed to be calling his mom. And I don't know what's transpiring with that. But yeah, you know, fun stuff, man. Fun stuff. I tell you what. I tell you what. Bum, 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 bum. Fun stuff. 37 more times before mom denied him, someone said. I don't even know what that means, but rather interesting. So what I've been doing throughout the day, yesterday and today, is trying to get finally caught up on all these orders. So unfortunately, I'm not going to have a lot of time to do this. And then I'm waiting for the gas company to come here and turn on the gas in the warehouse because they had an issue. So apparently whoever was in this warehouse before never paid their gas bill. And so they tried to tell me that I was responsible to pay a multi-$1,000 gas bill. And I was like, nope, here's my lease. I began it on September 1st. So long story short is they apparently are coming at some point today. So I've got to wait here, which sucks because I don't really want to wait here. I've got a ton of stuff to do. I got to get these damn cookies out of my house as well. So I have to package all those and find a UPS drop-off point where I can do that. But I'm taking all the coffee orders from Pure Truth Coffee, moving them over to Cafe Gratis. And so you'll get an order. If you had a Pure Truth Coffee order, you will have a gratis coffee order. It's going to automatically send it out. And then that coffee is going to go out today. If you have K-Cups, depending on what it is, I'm going to cancel and refund your order because I can't. It takes me to do approximately 30 K-Cups. It takes me about an hour and a half. And I can't waste that much time doing this. So I'm just going to cancel those orders unless you tell me you just want a bag of coffee. So, and by this week, everything will be all situated. All the mega boxes the mega boxes. I'm waiting for the shirts. They've already been shipped UPS, so they could be here at any moment. And yeah, you just got to do what you got to do. I can't do the K cups, manually. They just take too long. I can't do it. So, but yeah, the cookies are in my fridge or my freezer rather. And my wife has been bugging me, and I have all the packaging and all the everything to ship them out. The problem is, one, I'm eating, 3 times the amount of what you guys spent on cookies and shipping costs because I never knew how expensive it was to double air ship shit to California. It's very expensive. And outside of that, too, I was ready to ship them on Friday, but I wasn't. I was waiting for the gas company all day, so I couldn't get them out there, and I didn't want these to sit because they're perishable. So long story short, they'll be going out. I tell everyone to get damn reusable. Well, see, and what I could do is give you guys K-Cups. Like anyone that did order K-Cups that doesn't want a refund, I could just send you a pound of coffee and 15 or 20 K-Cups in a plastic thing, and you could just literally make them yourself because they're self-sealing. They're actually pretty cool, but I don't have time to do it because then I have to weigh each one. It's too crazy. It was a good idea, but luckily we didn't have a lot of people do it, so which is good. But I'm just gonna go right back to this court cam because I'm on a roll on switching these orders over, so I'm gonna do that and just deal with that. They are in break because he's been removed from the courtroom. So I will come back. I'm just going to throw that up for now. And they're not taking like a 15-minute break. They'll come on in any minute they'll come back.
Madam Clerk, might I please get verification that the audio and video are working in the neighboring courtroom? All right, thank you. I do have verification. There are headphones on the table in front of Mr. Brooks should he choose to wear them. I see he's reading from a book at the moment. I do need to make a record that this morning, although Mr. Brooks was not raising his voice, there were repeated interruptions. He wanted to debate rulings that I made after the fact. Just this morning alone, about 26, 27 different times he interrupted me or spoke over me. Once I made a decision on his motion to dismiss and his request to recall a witness, he then asked if for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He asked for a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer, specifically as it relates to the request for an interlocutory appeal, since I would not be the judge or court to which a request would be made. That is something that would be made to the Court of Appeals. And although I would have authority to grant a stay pending appeal, there is no appeal that's pending. I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom. I believe I gave that warning at least twice. Of course, this comes on the record before this court over the first 15 days of trial, where Mr. Brooks has, by his conduct, forfeited his right to be present on a number of occasions due to his conduct. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I need to have and an advisement of his rights that I need to go through. And I simply am not able to do that with him constantly interrupting me and then not respecting the oral rulings that are made. Of course, at any point in time, Mr. Brooks can ask to be brought back over to this courtroom under Illinois versus Allen. Of course, he needs to pledge that he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I, of course, have repeatedly, even without him making such a pledge, brought him back into the courtroom where I felt a sufficient time has passed, and he at many times has been able to conform his conduct. I would note during the vast majority of the testimony that was provided during the state's case, he was in the courtroom. If not during the entire time, he was able to cross-examine witnesses. We had a couple of issues during the testimony of witnesses he called. And of course, last Friday was, in my opinion, probably one of the most challenging days, I should say, to date. It's my hope that we can continue with Mr. Brooks in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. Mr. Brooks, you have been muted. I will make that, put that on the record as well. I will unmute though and ask Mr. Brooks, because you did not answer the question previously, other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse to call today? I need an answer to that question, sir.
So we address the subject matter jurisdiction that we haven't addressed when I was just over there, or since I've been over here? Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
This is the jurisdictional challenge right here. So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity, you will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted. I'm not sure. I don't know when you muted me or when I'm not muted.
Well, me muting you doesn't affect you being able to hear the court because
Yes, it does.
that only
Yes, it does.
mutes your audio coming into this courtroom. I confirmed already
Why is my
that
audio muted to begin with?
that is simply a misstatement. I confirmed with the bailiffs that the audio and visual were working.
Why is my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning and specifically now?
What you talking about?
I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning? He's been unmuted though, for a while now. We can obviously hear him.
Headphones on, if I heard it.
I will ask Mr. Brooks a third time. For the record, he's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear. I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir. I've
You are
confirmed.
lying on the record.
All right, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses other than perhaps himself. I then specifically asked him about Dawn Woods because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves a witness in their own case. They talk at length in that case about how rights Even constitutional rights can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that. I'd ask Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point. He's unmuted. I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear. Mr. Brooks, I would like to go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin 20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turned. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that? No response by Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that? Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by Mr. Brooks. It's my understanding that Mr. Brooks has the equivalent of a 12th grade education. that he attended school either up to or through 12th grade and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours or any drugs or any alcohol? I'm not receiving a response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you going to verify it on record?
So he did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
You saying. So if you can hear me, I don't hear everything you saying, and you know I don't hear everything you saying. So cut the crap.
Mr. Brooks has interrupted with very disrespectful words at this moment. I believe that he is feigning his inability to hear and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio, are simply false.
So
Mr. Brooks, have you made...
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said. So I would appreciate it if you would make the record clear and correct.
Clearly, he heard me say that for him to make that distinguishing statement.
I'm sitting right here. Don't you see me looking all up to the microphone so you can hear me?
I don't have an issue hearing you at all, sir.
Can you hear me when I'm right here?
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
Now, have you made a decision to tell me?
I will ask you again, sir. Have you made a decision to testify in this case?
To address subject matter jurisdiction? Have you made a decision to be impartial? To answer what your name is? To answer if you have a claim against me or don't?
I'm going to mute him for the moment just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction. He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them. I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the question in the affirmative, I will interpret his failure to respond as a no and that he is not going to testify. So once again, I am unmuting him. Sir, have you made a decision on whether to testify in this case? There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want
So
to,
how long have I been unmuted? Did you just
sir, do you want to testify in
You
this
just said you was
case?
muting me when I had the headphones on just a minute ago. You just said you was muting. So when have I become unmuted? Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one last time. Do
didn't
you
ask
want
me
to?
nothing because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to
You can't answer
testify?
for me.
All right, I'm
You
going
can't
to
answer for
answer.
me.
I'm going to
You
mute
can't
him
answer
again.
for me.
Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court. This court, as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum. Again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial. His repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom, because this morning alone, he is yet to conform his conduct to the simple standards of courtesy and decorum that are required of all participants in these court proceedings: the court, the prosecutor, the defendant, the jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court regarding his right to testify. I am unmuting him and will attempt to go through this procedure once again. If he fails to answer these questions, then he is forfeiting his right to testify by his own conduct. I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks, do you understand and are aware that you have a constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware, so why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify, and that if you choose to testify, that you would be subject to cross-examination by the state. Did you hear me say that?
I didn't hear you say anything. I don't understand what you're asking. I don't
He is
understand.
willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying to.
Did you hear me say
answer
that?
Questions for, I didn't hear you ask me anything. And
Sir?
I don't understand.
Stop talking and I'll ask it again. Sir,
Can you ask me to stop talking?
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do this one last time.
Yeah, I can hear them. I got the headphones on.
All right, then let's.
Obviously, you can see that.
Once again, Mr. Brooks is being disrespectful. He is
That's not being
blurting out
disrespectful. I'm
information.
saying
He
the
reverts
fact.
back to subject matter jurisdiction.
saying
He
the
accuses
fact.
this court of not honoring its oath. He just accused me of practicing
haven't.
law without a license. Again,
You
all
haven't.
attempts
No, I said
to
practicing law
deflect
from the
away.
bench.
I'm
I
going
said
to mute him
practicing
once
law.
again. This court has simply tried to no avail to get Mr. Brooks to answer simple questions, confirming on the record that he has been advised that he has a constitutional right to testify, and that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure. He would not even answer simple questions regarding his right to testify and whether he heard that or not. And based upon, pursuant to State versus Anthony, and looking at the balancing test that this court must consider, this court simply cannot allow Mr. Brooks to get on the witness stand unfettered without an acknowledgement that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I've provided the legal basis on the record, or in the case of subject matter jurisdiction, even when there's a written determination on the issue. When looking at State versus Anthony, this is a case where the Wisconsin Supreme Court was faced with a similar situation, although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence and the rules of procedure. as State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Those restrictions, again, fall primarily under the rules of evidence and the rules of procedure. The court in Anthony cited the U.S. Supreme Court from Arkansas versus Rock, wherein that court stated the right to present relevant testimony is not limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process. For example, numerous procedural and evidentiary rules control the presentation of evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that a defendant may forfeit his right to testify by his conduct. Whether a criminal defendant may forfeit his or her right to testify through conduct incompatible with the assertion of a right was reviewed by that court. That court went on to discuss waiver and forfeiture and ultimately went on to conclude the following. We now conclude that the right to testify may in appropriate cases be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. The balancing test that this court must go through are the interests, again, as I've already stated, for the rules of evidence, the rules of procedure, civility, and decorum, and balancing all of that against Mr. Brooks's right to testify. This court is not making an arbitrary decision. The decision I make here today is, in my opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout this trial, and specifically today based upon his failure to even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer the questions would be taken as by this court really as no, meaning the specific question, have you made a decision? And as for all of those reasons that this court will make a finding, he has forfeited his right to testify. With that, then, there are no other witnesses to present for the defense. Before I bring the jury out, I'll ask the state if you intend to call any rebuttal witnesses.
We have no rebuttal case, Your Honor. Thank you.
All right. I would like Mr. Brooks to be brought back over so that he is present in the courtroom when the court advises the jury that the defense is resting. I realize that will be over his objection. I'd ask that he honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence of the jury, I will bring you back over for that. Are you willing to make that pledge, sir?
Make what pledge? I'm not making no pledges.
Sir,
You're trying you asked me a question now I can't answer.
Yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent. How can you coerce me into my right to remain silent? So you're not going to protect my constitutional rights? Because I didn't answer nothing that you was trying to ask me before when I had the headphones on, and you can't make a decision for me. You can't do that. You're violating my constitutional rights.
Sir, if you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
when I know. You can't tell me what I decided to do because I didn't decide to do or not do anything.
Are you
By
willing
law,
to?
Your Honor, by law, you cannot coerce me.
I'm not coercing you, sir.
Well, you're making a decision for me based on something that I did not say myself.
Last Friday, I specifically directed your attention to State versus Anthony. I discussed very briefly at the end of the day on Friday the case law that is relevant on this topic, including State versus Anthony, Rock versus Arkansas, and Chambers versus Mississippi, to specifically put you on notice.
Did you recall what was going on Friday?
Mr. Brooks, I'm going to mute him again. I'm not going to have a debate. I've made a finding. I've given him yet another opportunity. If he's willing to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent. His lack of consent to this entire procedure is noted for the record. Based on his inability to pledge to this court that he will honor that ruling and be respectful of the jury, I'm going to leave him in the other courtroom. The jury's going to be brought out, and he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom and that his appearance from the other courtroom should not in any way be held against him or influence their verdict in any way. I will tell them that there are no further witnesses for the defense, and then I'll ask the state if there is any rebuttal, and then the jury will be excused for the day, because we will have I anticipate will be a very lengthy discussion on jury instructions. Again, I will advise Mr. Brooks that if at any point in time he wants to come back over, he needs to advise the bailiffs, but it does need to be accompanied by a pledge that he will follow the rules of civility and decorum, and he will not specifically challenge the court's rulings regarding closing off of his ability to call witnesses or testify on his behalf. All right, let's have the jury brought out.
Yo, what's up, motherfuckers? Shout out to Desiree with the $5
Thank you, everyone.
Venmo.
Please be seated.
Also, I think we have a Cash App for $10.
Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way, and must not influence your verdict in any manner.
Mindy.
At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day so that the parties and I go through all of the jury instructions, and I anticipate bringing you in tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not, by tomorrow evening, sometime Wednesday morning or early afternoon. With that, I'll rise for the jury then. Please turn your notebooks into the civilian bailiffs. I'll give them back to you during deliberations.
That's, what is this saying? Oh, that's right. It's called Fuck Around and Find Out. I wrote a song. Ready? Fuck around. He found out. Yeah. Fuck around. Darrell found out. Darrell found out. Darrell found out. Darrell found out. He's gonna be 6 feet underground. No, he's not. He's gonna get 6 life sentences.
Before we begin,
Yeah.
I will have Teresa print off what at least we do have for both parties. I'd like to take a short comfort break. I'll invite Mr. Brooks to come back over, and then we'll start with that jury instruction conference. We'll take about 10 minutes. Thank you, everyone. We are in recess.
Yo, she woke up on the right
Side
side.
of the bed, didn't she? She really did. She woke up on the right side of the bed today. She ain't messing around. She ain't taking no numbers for the day. She's feeling feisty. Oh man. So the oil is turned on, or the gas, finally. So now we have heat in the office side, but guess what? The furnace in the warehouse doesn't work. It's okay. I don't need, as long as it doesn't freeze, which it likely will in the winter. Oh man. So I just messaged the landlord and I'm like, hey dude, we're homies, right? Don't get mad. But I'm like, yo, home skillet. Gas don't work. And for the furnace in the back. Oh, by the way, remember that hot water heater that you said you were going to replace when I first moved in? You didn't do that either. I haven't had hot water in this office since we moved in. Do I sound like Kermit the Frog? I don't even know why I did that. Oh, man. I've busted my butt this weekend. Like I just want to lay down and watch TV, but I can't because we're covering the trial for you. Does it have a bad pilot light? No, because it's the same light or same line that's coming in. So when the gas company came in, it runs to 2 furnaces. So it goes one to the furnace that's up above. So the way this is, it's like an empty shell, right? And then it's got the 2 offices that are built into the warehouse. The air conditioner and furnace for the offices are up above on the, because it's got I think I've showed you guys the warehouse. Should I show you it again? I can. It's pretty easy. It's fucking messy right now. But why not? Why not? Let me copy this. Copy. And then let's send it to myself. You guys want a tour of the office / warehouse? Control. What is it? Nope. No. Oh, there it is. April, ignore that link that I just sent. It wasn't for you. I sent it to the wrong one. All right. You want a tour of this bad boy? The warehouse is pretty messy because I've been working all weekend long. But watch. Let's see if this works. What the shit? Oh, wait. I'm hearing feedback. That's really annoying. Camera facing back. That's the one I want, right? Yeah. Yeah. Now watch. Solo. Oh, wait. Hold on. I don't know why it didn't work. Oh. Is this why? Come on, fucker. Oh. Dude. Let's see. Let's see. Let's see. Let's see. Wait for it. I'll figure it out. Hold on. I know there's an echo. You guys seriously saying there's an echo? My goodness. What? Does it not allow me to add anymore? Like, how do I add? No. Here, let me just switch this. Wait, why is it doing that? Oh, done. Bam. There. All right, now let's see. Now watch. Let me. This one. You guys shouldn't hear an echo now. Maybe not. Or maybe you will. So yeah, so that's where I work all day, right? Nice. That's them offloading a car. Yeah, so this is the other part of the office. There's chairs and all the boxes. These are the boxes for all the cookies. And then here's the warehouse. Like I said, it's messy. That's a bathroom. And that's where I do all the sorting. Like, here's all the coffee I packaged this weekend. So much coffee. It took so long. And then here's all the whole bean. And I didn't finish either. I have more whole bean. You could see it over there. I haven't finished packing it yet. And then that's that furnace that's not kicking on there. And there's up on that mezzanine, there's another furnace, which you could see right there. That one is now working. That's a new screen print thing, but it's not even set up because I just don't have any time. But yeah, boxes. I don't have a garbage here, so typically what I do is I take the boxes, break them all down, throw them in the back of my car, and go. But as you can see, yeah, it's this is what I do when I work in the weekends. I make a big mess, and then I'll take the afternoon today to clean it all up. But here's the new coffee. That's the Flying High French roast. The medium house roast, if you guys do order on gratiscafe.com, the medium house roast is the Awake Not Woke. French vanilla, Harlem's Finest, the pumpkin spice, Italian blend. That's a new one. That is a super dark bean. But Italian blend, breakfast blend, and then our Supreme Dark. But even the Italian is way darker. The beans are about as dark as these bags. These are our older flavors that are going to go in the boxes when we put them out. And here's all the whole bean. I didn't realize that for pumpkin, it didn't have whole bean in it, which it was supposed to. So I added that this morning. But there's my wife's car that I now use because she broke it. The trunk doesn't like stay closed all the time. But yeah, I don't know why it's all zoomed in. I wish it wasn't quite as zoomed in. All right, but now I got to shut up so you don't hear an echo. It's trippy. Wasn't that nice? Wasn't that nice? Someone said he's going to be mad. Steve needs to call a furnace guy. I don't need to call a furnace guy. Someone said, where's the trial? The Smooth Operator 3 said, where's the trial? They're on a break, buddy. Chill your horses down. Is that what a horse sounds like? I don't even know. But there, you got a tour of my little warehouse/office. Because I know a lot of people say I do it, the show from the basement. Now you all can be like, actually, he doesn't. But yeah, just busting my butt every day trying to make it. I always thought the lighting in there was dim. No. Oh, you thought no, it's a studio, green screen and everything. Got the big lights right there. Hold on real quick, because my wife said hello. Always got to text the wife back. Those windows are amazing. Yeah. There's actually another one right here and behind there, which you can't see because of the green screen. But yeah. Watch. I'll show you actually. See? You never would have known, right? Because the big green screen there. Fancy stuff. It's called high-techery. High-techery. That's what I call it. Fuck, dude. I have to... So now that's done. So the only thing I'm waiting for, this trial is going to suck today because they're going to be doing a lot of, someone said live audio is still wonky. No, it's not. Someone said the audio is still bad. Huh. You do a better horse than a chipmunk. I think my
chipmunk is pretty spot on.
But audio is fine. Good. Someone said, Steve, is that wall heavy? No. But yeah, so trying to figure out, I think I got to do shoulders at the gym today. I should make like a special, like, contribution, like if you guys want to help buy the gym equipment, and then I'll just live stream like right from here while I'm working out. You guys could see my workout routines every day, but it'll probably scare you because of how much weight I throw around. But in all reality, it's so fucking expensive. They want like $2 a pound for Olympic weights right now. It's insane. Because I like simply can't afford it. We got everything going on with the coffee shops and all that. I can't afford gym equipment right now. Are you kidding me? That's why I'd just rather go to the gym. Long day already. Long day. Did he get thrown out of the courtroom? He did, yep. Just throw around a few Priuses to warm up. Yeah. DOJ is addressing a national security issue at 1:30. Yeah, we'll see what it is. Because probably what is probably going to happen is as soon as the trial comes back on, I will shut up. I will run to the post office, drop off all the packages that I have done, and then I'll run home. Oh, fuck, my lunch is here. I should eat my lunch now, then do all that is what I should do. If he would just be quite what? Metal Jess. If he would just be quite, LOL. How much are gym memberships? My membership, $60 a month. It's $29 every 2 weeks. Gym memberships have gotten so expensive. I remember years ago when I first started working out, gym membership was $10 a month. And then when we went to Florida, the gym membership, I think, was $39 a month. Then I switched to a powerlifting gym. That gym membership was $50 a month. Then we moved up here, and I just go to a regular commercial gym, and it's $29 every 2 weeks. But However, my contract is up. So as soon as I do get the gym equipment, I could just not, I could just cancel my membership. So that's good. Patty said, will you be offering a discount for seniors on coffee ground purchases? No, on gratiscoffee.com. If you're ordering the coffee online, no, there is no discount because we offer free shipping on everything. So we can't do a discount. However, when we open our coffee shops, senior citizens drink free cups of coffee along with everybody else because it's a free coffee shop. But no matter what, you will still get a free cup of coffee. How about that, right? Respecting our seniors. Someone said, in my hometown, we have a family membership for $32. Yeah, I mean, what I want to do is I want to open this because for example, I have this warehouse, which I just showed you guys. And then on the other side of this building, I have another warehouse that's approximately 25 foot by maybe 40, except there's no build out in it. So there's no bathroom, there's no offices or anything. It's just strictly a warehouse with a big roll up door. And there used to be a powerlifting gym there. So my plan, and the reason why I got both of them, because they gave me that for $500 a month. So I was like, I have to. The reason I got both is eventually I'll open up a gym down there. But then I was thinking about it the other day. I could move the coffee and shit over to that side and have a gym here. This would be a nicer place. Plus we already have the bathroom, but do I want that many people? These walls are not very soundproof. So probably not, but do we ship free to Australia? No, we only ship in the United States. So that's it. I believe that it will try to charge you, but it'll try if you live outside of the United States. And then you'll also see too on the site that is puretruthcoffee.com. I'm going to be switching that over. It's just going to be Steve Oatley, but that's where I'm going to have all of like the shirts for the shows, different stuff, all the mega boxes and all that stuff, mystery mugs. All of that will be through that website. And then I can separate. So anything purchased on that store will be like support for this show. Anything, all the coffee purchased through the coffee company will be all separate. So it's a little bit easier that way. Some said our family membership is 100, but it's Washington State. Need I say more? Yeah. But what I was saying is when I finally do get everything together, get all the gym equipment and open this gym, we're just going to do 50. Because the one thing I don't like is gym memberships. I like, a gym, but I don't like how it's like a year you pay a $500 cancellation. I don't like that. So what I would do is just be a true month to month place. But that's what I'll do. I'll just end up getting gym equipment slowly but surely. Someone said he's going to be big mad because he and Mama can't testify now due to his tantrum. No, he's not going to be big mad because he didn't want to testify anyway. He knows already. He's just delaying stuff. He's going to pretend like he wasn't given an opportunity or some shit like that. But we all know that's hogwash. Yes, I am smiling because I said hogwash. Isn't that funny? I don't care who you are right there. Sue Parker, I did refund your K-Cup order, by the way. So, we got another super chat. Smile with a $10 super chat. Thank you, duders. And there was one earlier, a $20 one right here by Wasted Time. Thank you for those super chats, both of you guys. You are my favorites on YouTube. You really are. On YouTube, yep. It's a long 10-minute break, isn't it? I mean, I already did a tour of the warehouse. I did everything. Hold on 1 second. The wife is texting me. She always texts me on her lunch break. And of course, you never keep the wife waiting. You always text her right back. Right? Someone said, yeah, it's been 20 minutes. Has it been 20 minutes? Did I pause this? Oh, no, it's still. Can you imagine if I paused it? And we all just sat here. Why couldn't we hear closing arguments today? Because they have to run through the jury instructions. The jury instructions are going to take a long time. There's nothing we can do about it. Nothing we can do about it, homies. You nailed that Scooby-Doo horse Winnie. Huh? Just your average liberal 30-minute, 10-minute break. I don't think this judge is a liberal. Smile with a $2 super chat said, this is a $2 challenge for anyone watching. They don't do challenges. All my YouTubers, my YouTube viewers, they don't do the challenges. Even if it's Cash App or Venmo challenges, people don't do it. They just contribute when they contribute. The challenges, I've seen some of the other streamers get those challenges going, and they make buco latte dollars. Not us. My fucking hair is long. I got to cut my hair too. Hey, chat, went to settings and changed quality from auto to source, and it fixed the audio. Oh, so it's Twitch. Twitchers are having an issue with the audio. Yeah, so switch it from audio to source, and then you're good. You know what I'm saying? That's how we roll. Let's see if they've... You are an awesome place to watch the trial. Court TV is only showing snippets. Oh, really? Tell the wife it's our Steve time now. Yeah, okay, no. She's working. So she's, it's just like, hi, love. How you doing? Did you do this? That's it. That's what it goes. That's what our time is like. But she's excited because my older boy is done with football. There's no martial arts tonight. So she gets to come home at like a normal hour. So she was very excited about it this morning.
On the record, appearances are as they were before. The record should reflect that Mr. Brooks continues to appear from the other courtroom. I would like to make a record regarding the audio and visual from the other courtroom. I've asked that one of the bailiffs who was present during the last session, present in that courtroom, come to this courtroom. I'm going to put him under oath and have him testify about the audio. I also have information from Zach Tremaine, our IT specialist. He too will take the witness stand. And I just want to make a full record of, he did a decibel reading regarding the audio as well.
They're not fucking
Right,
around.
Deputy Kibler, if you could take the witness stand, please. Sir, could you please raise your right hand? Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
It is.
Thank you. Please have a seat. Please state your first and last names for the record.
First name is Nicholas, last name is Kibler. First name Nicholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom into the neighboring courtroom.
I could.
All right. That's the only record I wanted to make. State, have any questions?
Just briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes.
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
It was.
And at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to come back in here.
All right, thank you. Those are all my questions, Your Honor.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy?
No.
All right, thank you. You may step down. All right, then I'm going to have Zach Tremaine also take the witness stand. Do you have, I have it up on my screen. Can you do a project it, please?
Can I just share it? Like if I share the clerk screen?
Yes. All right. There is, first of all, sir, stand and raise your right hand. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right, thank you. Be seated. State your first and last name for the record, please.
Zachary Tremaine, Zachary. Tremaine is Tremaine.
All right, and what is your position with the Clerk of Court's office here in Waukesha?
I'm the IT coordinator for the Waukesha County Circuit Courts.
Were you in courtroom 20 this morning following Mr. Brooks being taken to that courtroom?
Only temporarily. I was there when the call started, and then we came back to do a measurement of the DV meter later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo, overlaid on top of what we call the X panel. It is our AV control panel. So you push buttons on it and actions happen in the courtroom, AV related. At that time of the photo, my phone is registering 67.3 decibels in that courtroom, and that was when the judge or the court was talking, and then the sound was coming over the speakers in the other courtroom.
And what, if anything, based on your training and experience, can you tell me 67 decibels means?
It's plenty loud. For comparison, I did a quick reading in the media pooling room, which is CG6 in our courthouse. The meter there was reading between 55 and 65. So it's louder than the audio feed going to the media right now.
All right, thank you. Any questions from the state?
Sir, I'm looking at the photo, and Your Honor, for the record, this photo will be made a court exhibit?
Yes.
Okay. I'm looking at your phone screen, and it looks like in the upper right-hand corner, it appears the time is either 9:26 or 9:36 a.m.
On my phone, yes, I believe our AV processor, which is the other time of 9:23, I believe that just needs to be updated, but
Okay,
it is approximately 9:26 when the photo was taken.
okay. Those are my questions.
All right, thank you,
Wait,
Mr.
I'm sorry.
Oh, go ahead.
Do you happen to know what the decibels are in this room?
I don't. I'd have to pull the same thing up on my phone while people are talking.
Okay, thank you.
Mr. Brooks, any questions for this witness?
Yeah, for the record, I don't consent to being called that name. Do you know anything about the hearing when someone has hearing loss in any of their ears?
I do not.
So it'd be fair to say you don't know if I can hear everything good from this courtroom.
I can tell you what the readout of the room is. Beyond that, I don't know.
Well, I can't see what photo that everybody else is in there seeing that was supposed to be made an exhibit. I have not viewed that, so I don't know what's being referred to when you refer to the picture.
I'll have to show you that in a different way. I don't have the Zoom up and running, which would have been the mechanism to allow for an exhibit to be displayed. I can start that and have that up momentarily. Fair enough. So give me a moment. For the moment, we'll print it in black and white so you have it until I can get the Zoom up. Sure.
You are in the meeting now.
I need to get the other courtroom in, so just one moment.
You have to hang up after the call.
Will I have to stop the Polycom, Zach?
Yep, you have to hang up and then join into the Zoom meeting.
Okay, hold on, please. Can you do that?
What am I doing?
Stop the call Polycom to Polycom, and then I'm going to call it in through the Zoom so I can share the screen with the exhibit, which will actually help when we do jury instructions.
Copy that. I'm hanging up. Are you calling again?
Yep.
Okay, good.
Except now both the room systems are out, so hold on. One more.
You are in the meeting now.
All right, so the record should reflect that I've now changed the audio visual from the Polycom unit to the use of Zoom. I've called in both courtrooms and they can hear from over there. And then I'll do, I just need to get back on so I can get the email. Give me a second, I have to go from double screen to single screen the way I sign in, but that'll take me just a second, and then I'll share screen so the color exhibit can be viewed by the defendant. All right, now the court is sharing screen and the image is being displayed.
Yeah, I see it.
You see it? Okay, thank you. Any questions regarding that then, sir?
My question was, pretty much already answered. You don't know if me myself can hear everything good in the courtroom, correct?
I do not, correct.
No further question.
Okay, thank you, sir. I'll stop sharing. Okay, thank you, Zach. You can step down. All right, I just wanted to put that on the record since that was an issue raised by Mr. Brooks previously. Now, I need to get a copy of the
They're coming.
jury instructions. They were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a written copy as well. Again, it's all the same, 107 pages, and then my written copy is on its way.
I set the value, return the value each document. That's if I'm not muted.
You're not muted.
I also would like to, again, ask for subject matter jurisdiction to be proven on the record.
Your request is
It
denied.
has yet to be verified. It has yet to be verified.
Your request is
Your
noted.
Honor,
It's denied without further hearing or consideration.
I was just told that, the evidentiary phase is supposed to be closed, how come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able to do? I've said I have numerous documents that needed to go into the record. Why have they not been permitted to be made evidence? I didn't rest my case, so I don't know why that's being told. And I have yet to be able to offer my exhibits into the record for evidence. How is that so, Your Honor?
Sir, the court did declare the evidentiary phase of this trial closed. I specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
They were not hearsay, Your Honor. I did what you told me to do. You told me, since I was representing myself pro per, that I had to write everything out and present them to the court.
So that's not what I said. You're misquoting me, but in any event, I'm
No, that's
denying
what
your
you said.
request. I
So
said,
you're saying that I have no right to present evidence and to have exhibits as the state's been able to do.
Mr. Brooks,
Are
I'm
you
not
denying
going to
me
have a debate about this
Are you
now.
denying
I
me-
have,
are you-
I gotta
are you
mute him
denying me
once
your
again.
right?
So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and testimony previously by refusing to answer the court's questions. I will specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number two, filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to testify regarding any statements that from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would allow this court to admit his written filings. I believe without fail, they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback regarding jury instructions. It's typically a back and forth. We'll go through them, and I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that, and then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Muted.
All right, you're unmuted now, but you have to not interrupt.
You can't, I'm not trying to interrupt, but how can you deny me the chance to put on an adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them, you filed everything that I gave to you.
All right, Mr. Brooks, I'm going to mute you because this is not relevant at this time.
It is.
He's raised tone of voice. He's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice. But if he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment. I'll unmute him again, but you are advised, sir, you need to be proper, you need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
You need to tell me why I can't present evidence. How can you deny me the fact? How can you deny me my right to present evidence?
All right, I will mute him once again because he wants to continue. And again, I understand he's upset. I understand that. But he has himself to blame for his conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions. First of all, has the state received a copy of the draft?
Yes, Your Honor.
Thank you. Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but do you acknowledge receipt of the draft of the final jury instructions?
I didn't acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the bailiff to pick up the documents from the floor and put them in front of him.
And I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on the defense. How can you tell me when I done stated
I'm going to mute him once again because, again, I understand he's upset. If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70. No, I don't want to do that.
Oh, you don't? I changed,
Hold on. 76, the 76 count, just want to make, it says near Frame Park, so it is in there, but that was just one question I had. All right. So state have any requests as it relates to the jury instructions?
Your Honor, I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far, though.
Okay. Fair enough, there's 107 pages. I certainly can give the parties some time to continue to read through them.
325,
This dude is the biggest child ever. He blocked the view with with the boxes. Fuck this dude. I'm going to instruct the bailiff to remove those boxes from the table. Unbelievable. Dude is so stupid. Stupid. He's a stupid kid, man. Let me tell you what. He's the stupidest person you ever did meet in your life. Is he getting naked again? I hope not.
Mr. Brooks is requesting to go back to his cell. At this point, I'm going to deny that request.
Hell
He
yeah,
can
make
remain
him
in the
sit
other
there.
courtroom.
Yeah. Yeah. Denied. We can't see you. Sorry, Mr. Brooks. You got to move those boxes out of the way. Denied. We still see you. Still see the top of your head bobbing and weaving. Look, he's yelling. Man, I wish the mic was on. I want to go back to my cell. No, you'll have plenty of time for that. Like 6 life sentences. You know what I'm saying? Like 6 life sentences. Okay. Yeah, exactly.
I know he's muted, but I can certainly hear him from this side.
Wow.
He appears to be yelling at the top of his lungs. I can't decipher what he's yelling.
He's yelling, "Shut up! Shut up!" Like that. Shit's copywritten though. Don't try to copy that song. Shit's copywritten. Me. Can they tase him with his ankles taser things? Wouldn't that would be kind of cool? At least I
advise
think
Mr. Brooks, without a specific waiver of his right to be present, even if it's from the remote courtroom, he's going to remain in that courtroom.
Hell yes, he is. Hell yes, he is. You get him,
require
Judge.
him to have a colloquy with me.
Yeah, colloquy all up in this shit, yo. Yeah. Gonna have to get all colloquy-ish. It's kind of like skirmish. Yeah. I don't even know what I was saying there. Ay, ay, ay. Yes, the jury is gone for the day. They'll be back mañana. That's tomorrow in Spanish, by the way, just in case you didn't know. I like to help you guys out. Scooby-Doo, ba-da-bee, ba-la-la-la-doo-doo-doo. So I guess this is a lot of stuff in silence. If you guys can hear that,
Mr. Brooks, I know you are still muted by me, but I know the audio is working. But I would ask you to specifically advise if there are any specific jury instructions that you are asking be read to the jury? Mr. Brooks, if you have specific instructions or categories of instructions that you believe this court should consider, I need you to write them down on a piece of paper. If you don't have, I believe I see a writing utensil. I'm not sure if I see a pad of paper. We'll make sure you have that. But given your current demeanor, which is still seems quite animated and a loud raised voice, I'd ask that you write it down.
And my microphone's on. See, those are the sound effects I make while I'm just sitting here fucking spending money, packaging and shipping shit, you know, all day. That sound, that pew, 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 is all my profits deteriorating because we had a shipping. Ah, fuck. Printer keeps jamming and I don't know why. Yeah. But finally, people will start getting their fucking orders. Finally. You know what I'm saying? Is he still making faces and stuff? I'm not watching. Where'd the other attorney go? Oh, she's leaned back. Lean back. He's pushing the table or something? Oh, shit.
How's the state doing on its review?
107.
Okay.
Ew. Someone's talking about whether or not he's showered recently. That's gross. Anyway, I'm going to go. I got to pack some boxes. I'll be back in like 10 minutes. We'll just leave this on for you.
just want to make a continuing record that Mr. Brooks is still, I can still hear him even though he's muted due to his level, his tone of voice and volume level that he is using from the neighboring courtroom. So all of these should be included, but they just put them in numerical order. So you hopefully haven't taken out any numbers. Yeah, there should be numbers. I can figure it. There are numbers.
Okay.
Well,
I was gonna say, there's some, like the ones that are in all of ours, I think you have
yeah. So that's just the easiest because this goes after credibility. And then 325. Which, it's before defendant elects not to testify, and we have to talk about that one. Yeah. Mr. Brooks, I'll advise you once again if there are any specific requests for either instructions or categories instructions that you want this court to consider, please write a note to pass to the bailiffs who can let me know.
Your Honor. The state has reviewed all 107 images.
Thank you. I know upon my review, I noted a few spots that either in the headings, some information or words that might need to be removed. But why don't you go through and tell me what requests you have, starting, and then we'll go page by page and just tell me what page number and what section.
So I think the first concern I have is with regards to the bail jumping. I know that we had charged, there's 2 separate felony cases. The defendant was out on bail. And I do believe it would be assistive to the jury to have the specific case number. So when we first talking about 61 of 107, we start talking about the bail jumping, and then we go specifically on page 63 of 107, when we could talk about count 74 and 75, I think it might be helpful to put the Milwaukee case number, because they are different case numbers, so that they know exactly what they're finding, that he was out on bail and that as conditions of his release. And those bail bonds were entered into evidence.
Let me look at the information.
And then just, because I think this was just well, I guess I'll have you, when we look at the verdict forms on page 102 to 107 for the bail jumpings, there's verdicts for the bail jumpings for 3 separate counts, 74, 75, 76. I don't think there should not be one for 76. I believe that should be the battery.
That would be true. My computer's just acting up a bit, so I'm going to search. I'm going to see what the information says. And then I'll ask Mr. Brooks if he has a position on that. Sometimes it's easier if we just list out, I guess, what the changes are requested. I'm going to make some notes, and then we'll go through them one by one. But so,
and I don't believe it was spelled out in the amended information.
Say that again?
I don't believe it was spelled out in the amended information.
Right.
So that would be page 63 of 107, whether or not we want to put the specific case numbers.
I can tell you right now, I typically like to follow the information, so I'm probably not inclined to do that, and we can argue that, though, to the jury. But let's go through the list, and then we'll get the defendant's responses if he would like to give us those. But we'll go through the whole list. So that's the bail jumping.
Yep, and then with the verdict forms with regard to the bail jumping, just to put on the record, page 102 of 107, I believe there's a count 76, which details it as a bail jumping. I believe that should be the battery.
Right.
I did notice on the motive instruction was incorporated on page 5 of 107. And I know that intent is an element of the battery. I don't believe that was incorporated. I mean, usually it's a standalone instruction. I think the court incorporated it with the first degree intentional homicide, because certainly that was
I think that's part of the pattern instruction.
Oh, it is. Okay, then we'd ask for motive. I think that there's a 175 instruction that could be given as a standalone.
I'll look at that. Okay, we'll add that.
And then on page 65 of 107, which is the 70, the preliminary instruction, defendant proceeding pro se. There's the standard paragraph, which is the first paragraph listed under this instruction, and then there's an additional paragraph. We are going to object to that additional paragraph. I think it highlights the defendant's bad behavior. So I'd ask that that be taken out.
All right, I made a note of that. Keep going.
Okay, with regard to page 106 of 107. I believe that those were add-ons at the end that the court wanted to question the parties about.
Yes.
I believe that there was 325 should be given. One of the witnesses for the state did testify. He did have one prior conviction. I believe a witness for the defendant testified that he had a number of convictions. With regard to that same page 106 of 107, instruction 141, where identification of defendant is an issue. I don't know if it is an issue. That wasn't raised during the defendant's closing arguments. His opening arguments. I would know that, or note that the defendant would sometimes cross-examine people on if they were able to see the person driving or the description of the person driving, and he would cross-examine them as to their ability to perceive that. So I guess that would really be up to the defendant if he wishes that to be given. On page 107 of 107, instruction 172, circumstantial evidence, flight, escape, concealment, the state that was included in the initial instruction that we requested, and I would continue to request that instruction be included.
It's really just flight, though.
Correct.
What's that number again?
172.
Yeah, I know, it's just not there. I saw it, it's fine. But only as to flight. I made a correction on it, just gonna find it. All right.
And I would say concealment to some extent, because he took off some clothes that would have identified him. But again, his running away, his trying to conceal his identity by removing some clothing that was identified by numerous witnesses as him wearing a hoodie or a light colored top.
Those are all, and do you have any requests as it relates to instructions that are not in the packet that should be?
No, Your Honor.
All right, let me turn to Mr. Brooks just to get whether he has his list. I'm not asking for a response yet, Mr. Brooks. What I'm asking you for is whether you have any requests for jury instructions, or if in your review you think anything needs to be changed, deleted, added, etc. I know I'd ask that it be put in writing, but I'll also give you this opportunity to verbally advise the court and make your requests. Do you have any requests as it relates to the jury instructions, sir? I would note he put two boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off because I can see the outline of his arms, and I can see the jacket on the back of his chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions.
And Your Honor, would it be possible for the bailiffs to just move the box off the table so we can
Yes, I think
see?
that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there.
Get him.
He has quieted down. I haven't heard him in a while. If you could move the second one because it can interfere with the microphone as well. And the third. Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell them to move my box?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey, man, you don't got to talk to me like that.
Do you have any requests
First of all,
Is that a request?
to
He
the,
says.
related to the jury instructions, sir?
Is that a request?
yeah, I got requests. It ain't like they gonna be honored though, because
As it relates to the jury instructions, sir, what are your...
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Welcome to the club.
Mr. Brooks, do you have any requests?
I'm tired of my rights being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up here and make decisions based on what you think I said when I didn't get consent for you to do any such thing?
Sir, I understand you may be upset, and I really do,
No, you
but
don't
I've made my
understand nothing.
determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't.
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you're saying.
Then you should put the headphones on.
Don't you understand? What about that don't you understand? If you see headphones, you can see everything. You can see boxes, but then you see headphones.
Have you asked for headphones to be provided, sir?
I shouldn't have to ask them. I asked for my boxes to be moved.
I believe they took them away previously because you were so agitated. They were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop. You sit up here and do everything you're doing and think God don't see what you're doing. You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury instructions?
Yeah, I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah, I
it?
got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image of sir. Now it's all this sir and all this. I'm gonna get where I'm going. Try to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
It's not double jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with? You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb twice. I'm already charged with the same count in Milwaukee. For the same case. It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect. You always want respect, but don't want to give it. I'm charged with the same bail jumping charge here that I've already been charged with. That is double jeopardy. You can't charge me for the same exact bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay.
That's the distinction.
Again, there is no distinction. It's the same charge.
It's the same offense. It doesn't mean it's the same factual basis, sir.
He is not charged with bail jumping with the data violation of November 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
All right, so we've addressed that, sir. What other requests do you have as it relates to the jury instructions?
I want to know why I'm even charged twice with the same thing. You can't charge me in pursuant to a case in Milwaukee that I'm already charged with bail jumping for. I'm already charged with bail jumping for that already. So you can't essentially say, oh, well, because you were already on bail, we're going to charge you.
It's a different data violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
Yeah, but I'm referring to the first bail jumping count. The first one. I'm not referring to both of them. I'm referring to one of them.
My understanding, sir, is there's different dates of violations as it relates to that. So I've noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
I didn't say nothing about counts. I said one.
Whether it's one count or both, it's denied.
Am I not being understood? You can't charge me with the same charge twice. You can't.
It's two separate cases, sir. There's two.
Isn't that 971.23? Isn't that the statute that refers to the double?
All right, sir, I'm not going to have an argument. This isn't fruitful. I understand what you're saying. You're saying there shouldn't be 2 counts of bail jumping. You believe it's double jeopardy. I disagree with that. There's
I'm
separate.
already charged with it though.
This is a circular argument, sir. It doesn't change the fact that, from my perspective, the 2 bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed.
They can't.
What other requests do you have,
You're not
sir?
gonna talk over me. Don't talk over me. Just like you don't want me to talk over you. Just like you don't want me to talk over you. Just like you don't.
Mr. Brooks, what other requests do you have?
And I just asked you not to talk over me. You've been making your record the whole time you've been over there. You had me muted. I didn't see no requests over there. I didn't write nothing to go over there. I let you do what you was doing. No matter how egregious and biased it is, I let you do what you was doing. Because we both know that what you're doing is not right.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that. If you can't answer my question, I'm going to move on.
You can't. I haven't given you consent.
All right, I'm going to mute him once again. He refuses to answer simple questions regarding if he has any requests.
Hey, real quick, guys, I'm going to run home and grab all the cookies. I've scheduled UPS to pick them up. So I'm going to run home. I'll be back in like an hour. All right. I'm leaving this live. Just wanted you to know.
Jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests. If he can stay on topic, I'll unmute. I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here is your opportunity to give me your other requests, not debate with me about prior rulings. Go ahead, Mr. Brooks.
Don't sit up here and try to play no game talking about you giving somebody an opportunity that you haven't gave me an opportunity to properly defend myself and put stuff into evidence, which I've asked you repeatedly to do before we even got to the trial. You told me we wasn't in the evidentiary phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. No, it's not. So please stop being incorrect, Your Honor. Please stop.
Do you have any additional requests as it relates to the jury instructions?
Yes. Oh. That first count 74 bill jumping needs to be dismissed. You can't charge me with 2 things. You can't charge me with the same charge twice.
All right, I've made a note of that. What's the next issue?
Either one county gonna charge me with it or y'all, but it can't be both. It's the same. It's pursuant to the same exact thing that I was on bill for. The same exact thing. The same exact case. So why are we giving the jury instructions on 2 cases from another county?
I've made a note of that. What other requests do you have?
Man, this is ridiculous. So I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is going to be found a reason for it not to be valid. What are we doing here, Your Honor? What is the
Mr. Brooks?
Why should I be here when
I've made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
Why are we even having jury instructions? Why do I have to even sit here in this courtroom at this point? Because everything you've been doing without my consent anyway. So you're gonna find a way to do this without my consent. So why do I need to be here for?
Your objection for lack of consent is noted for the record.
Okay, yeah.
Any other requests, sir?
You talk a good game. You talk a good game to save yourself enough space. But everything got put up that has no merit in your court. None.
Right. I've asked him many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions, sir?
You can't move on because I haven't given you consent to.
All right. He Did not answer. So I'm muting him again. The only request that he has made as it relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct alone, as I've outlined already on the record. So the only request that he made was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury. However way I interpret it, I'm denying that. All right, let me go through the state's.
Your Honor, can I add one more?
Sure.
I'm sorry. 154, summary of evidence. I believe we had a map, actually two maps that summarize the, we had three maps. I think the one was summarized his route, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade route.
I'll make a note of that. I don't believe I saw the jury view instruction either. That was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of 152. All right, so let me go through the list from the state. Turning to page 61. So I've considered the request by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There's evidence, of course, that was received regarding the two separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and make a determination. As to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions, that obviously the third count of bail jumping is incorrect. That needs to be battery, and that change will be made. I'm also having Madam Clerk include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case I want to be very clear with all of the numbers. So I think I've addressed the first two bullet points. As far as the motive instruction as a standalone, I believe that is appropriate, and I'll instruct Madam Clerk to include that. As far as where it goes, I'm going to just, any instructions that we add should just be in the numerical order, unless there's a other request that's made. Then the state also made a request as it relates to jury instruction 70, which is found on page 65. So as it relates to this, the state is asking that I simply instruct the jury based on the pattern instruction and not include that second paragraph. I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said, "At times Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any manner." What's the state's position on including that but taking out the paragraph you request to be taken out?
It's fine.
Mr. Brooks, do you have any position on that? Which is, so jury instruction 70 has to do with the defendant proceeding pro se. The pattern instruction would be basically the first paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting them there, I'm not putting them there to just take me, I'm putting them there for a reason. I'm not letting do with her being able to see.
Mr. Brooks, do you have any position on the verbiage of jury instruction
Don't ask me-
70
don't
on
ask me
page
no question.
65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your
All
Honor?
right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this. I agree with the state. I don't need to highlight with that second paragraph. I will take that out, but I will include in the paragraph that reads, at times, comma, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner. Inclusion of the instructions that were put on the last couple of pages include 325 impeachment of witness. Its prior conviction, the part about juvenile adjudication, should be struck from the heading. And it should read, evidence has been received that one or more witness in this trial has been convicted of a crime. There were 2 witnesses that was applicable to. The remainder will be as is. And that was 1 witness for the state, 1 witness for the defense. I just will add that if Mr. Brooks has any position about these requests, he should, he is currently muted. He can raise his hand and I'll unmute. Otherwise, he can pass a note to the bailiff or simply tell the bailiff, who can then tell me and I can unmute him. But unless he tells me that, I'm going to assume he's made a decision not to provide further comment based upon the last statement he made to me. Then 141, I believe that's appropriate given the evidence that has been received. That's on identification of defendant is in issue. That I will instruct the jury accordingly unless there's a request from Mr. Brooks to take that out. Is there a request from you, sir, to take 141 out? I'll unmute for that purpose. It's found on page 106 because it's at the end of the instructions. This is the instruction on identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case. Do you have any position on that, sir? You are unmuted, so you can simply answer yes or no. No response. Then 172, circumstantial evidence, flight, concealment, I believe is appropriate given the evidence that has been received during this case. Yes, sir?
Am I unmuted?
You have been.
Am I unmuted?
You are.
So how long before you mute me? As soon as I say something?
Depends on what you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsive to what you guys are doing? Nothing I say even matters at this point, so what's the point of me being responsive? You can't make decisions for me.
Mr. Brooks, I'm going to mute you unless you can participate in what we're doing, which is discussing the jury instructions.
I'm gonna tell the jury the truth. That's what I'm gonna do. I'm gonna tell them what hasn't been told to me. I haven't been able to.
Mr. Brooks, I'm going to mute you because we're trying to discuss the jury instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct Madam Clerk to take out of the heading the word escape. Should just say flight concealment. And then I've reviewed 154. I believe that's appropriate. I'm going to pull it up just as a draft. I'm not sure if there's anything that needs to be. So the pattern instruction talks about a chart. Is there any request from the state as to just keep that or modify that in any way based upon the evidence that was presented? Because you actually submitted maps and things were received. I don't know that summary.
I think that there was a summary of the victims and the associated counts. I believe that that was exhibit 141.
But that was received, wasn't it?
And there were some charts of the extreme dance team, the formation, and dancing
Right.
grannies.
Do you have the exhibit list, Madam Clerk? What are those numbers again? I wrote 141.
We're just looking for the extreme dance and dancing granny charts.
Grannies is 54.
54 would be the dancing grannies,
Okay.
33 is extreme.
and 33 is the extreme dance team.
So 54, 141, and 33.
Yes.
Do you think the use of the word chart is correct, or should that be?
I would say diagram and maps. The court has allowed the use of diagrams and maps to organize the evidence.
The maps were evidence, though. What this instruction says is the court has allowed the use of a chart to organize the evidence and to assist you in understanding it. The chart itself is not evidence. It is a summary of some of the evidence that was permitted or presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence.
Then we think 154 should not be given
That's what I was wondering.
because
So
they were all admitted.
They were all admitted based upon how they were presented and the
I apologize.
testimony regarding them. Typically, where that comes in is for use in openings and closings solely that are based upon evidence, and we anticipate those things coming in, not when there's been an actual document that's been admitted. So I don't think 154 is needed, and I'll deny that request. What about 152 regarding the view?
Your Honor, as I read that, that was given prior to the view, and I think that was appropriately given at that time. I don't believe it goes into the closing or the final instructions. would
That
be
was
position.
my inclination, but I wanted to get the party's position on that. I'll once again unmute Mr. Brooks and just ask him if he has any position regarding any of these last issues that we've discussed with, as it relates to the jury instructions. Anything from you, sir, on the jury instructions? He's not responding to the question. I believe that covers all of the issues that were raised by the parties then. You are. I'll give you one final opportunity to tell me if you have any requests as it relates to the jury instructions, sir.
What you mean you giving me one final thing? I didn't get into none of that y'all been talking about. And I say y'all because I haven't been participating in none of that.
I understand, sir. Your objection's noted. Your lack of consent is noted.
Okay, I don't see what's going on in there. So how's decisions being made without me being able to consent to it?
Sir, you forfeited your right to be present in this courtroom by your conduct, and you have not
No,
requested to come back.
Actually, you took a break. So let's make sure the record is correct. You took a 10-minute break.
I did.
At which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been forcing me to come over here from the get-go. Why couldn't you force me to come back over here where I'm supposed to be at?
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you wanted to come back in, all you needed to do was ask. You've done that previously.
Yeah, but
And even during this time, though, you've been incredibly disruptive.
I can't say that.
At one point you were muted for an extended period of time and you were yelling so loud, sir, we could hear you in this courtroom. I couldn't decipher what you were saying, and I was also made aware that another branch could hear you. So you continued your disruptive behavior.
That's fine, because at the end of the day, I should be heard. I have the First Amendment right to be heard. So if I'm going to be constantly muted, the only way for me to be heard is for me to raise my voice.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them, and I'm going to take a break, and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
You can't force me to do it, though. You can't just say, I'm going to do this. Because
sir, but you also can't stall the proceedings by failing to answer.
I didn't try to stall the proceedings. You the one that held me in contempt.
I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk, finalizing the order, print them off again. She has been working on the verdict forms, which are of course separate, which need to be approved by this court. So those will be printed off. A set will be provided to the state. A set will be provided to Mr. Brooks. We'll take I'll do a 90-minute lunch break. So it's 11:27. So we'll come back at 1 o'clock to finalize the verdicts and the jury instructions.
And Your Honor, with regard to sequestration of the jurors and the alternates and those issues, did you want to address those this afternoon?
Yes.
Okay.
We can do that.
Thank you.
I can put on the record that I had the civilian jury bailiffs provide the parties. We have a letter regarding sequestration. There's an emergency contact form. So all of the jurors were made aware of that. They know that. Of course, once the case is, all of the instructions are read and the parties make their arguments, and then there's some final instructions at the end, and the case goes to the jury. Obviously, only 12 of the 15 will be deliberating, but we can make a more full record of that this afternoon.
Thank you.
All right, we are in recess until 1 o'clock. I'm just instructing the parties to stay until the handout of the verdicts, and then you can leave for lunch. Thank you.
Woo! Man, I'm a beast. I'm a beast. I made it home, then back here, and then packed all the cookies. Whew. I am out of breath. Because here's the thing. So anyone, if Crystal, Catherine, James, Melinda, or Julie are here, shout out to you guys for buying the cookies for that benefited my son. I will never, ever, ever do this again. For one, I had to buy the shipping labels, not including the shipping supplies. The shipping supplies were about $200 because I had to buy these little, not dry ice, but ice packs. I had to buy big insulated shipping things. And then I just bought the shipping, and the shipping was $250, which sounds like a ripoff considering the cookies only cost $250. Do you know what I mean? So I've spent what you said. That's like my donation to my kids' football thing. So I sent out the cookies to everybody. Now I will tell you, well, hold on. I moved the form. Not Crystal. There's someone that only ordered one. Melinda King. You are the only one that got the cookies actually in the box that they come with, because I couldn't fit them for any others. So James, Mick, something. I'm not. Julie, who's a normal viewer. Crystal, Catherine. You guys all got yours cookies in with a bunch of, they're in the plastic bags. But whatever. I sent you the cookies. If you don't like it, or you're like, Steve, the cookies are no good, even though I paid for either next day air or second day air, just send me a message and I'll refund you the $19 for the cookies. But I'm doing the best that I can to be awesome. I'm very tired. Tired. But I got a bunch of coffee orders. So if you got a shipping notice today for any order, then it's on its way to you. I already dropped it off at the post office because I'm pretty awesome, I have to say. Quite awesome. Someone said you should see the news article about people throwing feces at something Sawant, Socialist Seattle Councilwoman's house, and how she's mad the police won't. Yeah. It was. Someone said, how much coffee did I drink? I'm twitching. No, I'm not twitching. And I've only had two and a half cups of coffee. I should have another one, but I don't want to. I'll finish my soda. Yeah. So this court hearing isn't shit. U.S. Attorney. Let me see if I can't find that video real quick. Right here. I don't think it's begun yet. Merrick Garland is going to be... No, that's not him. So they were doing sound checks. Merrick Garland's going to be holding a meeting here in a few minutes. So someone said twitching from the stream, though the stream is glitching, is what someone else said. DOJ is announcing their false flag. No, what they're going to announce is that Russia is attempting to hack into the 2022 midterms. I can almost guarantee it's going to be Russia, North Korea, or Iran, or maybe they'll throw in Saudi Arabia now with something that is unverifiable that the United States government is going to implicate, another country on in an effort to take the focus away from the fact that Joe Biden fell asleep during a live press conference or a live interview the other day. And whatever they can do, it's like throw shit at the wall, see what sticks. So that is my opinion, that the only reason this announcement, because we didn't even know anything about this announcement until this morning, the only reason this announcement is coming out right now is because Joe Biden got really negative press this weekend. Very negative press because he fell asleep. And, they want to vilify Russia further. So they'll probably, that's my guess, is they're going to say Russia as a state, because they're saying that's what they're saying, a nation state acted against America's interests. It would be funny if they indict themselves, right? For acting against America's best interests. Because you could make a logical argument saying that the United States government is actively working against the benefit of the United States citizens. But that would be a little bit too real, and they would never actually do that. You know what I mean? They wouldn't do that. Anyway, I do want to give a shout out to the social media commentator, or like the people who made donations through those platforms, the super chats and all that stuff. I've decided that if you want to use those platforms to send contributions, go for it. You know, obviously the best ones are the ones that we have over there, you know, because I get them right away. There's no percentage or anything. But if you guys like the live streams and you want me to keep doing it, hell, I'll run consecutive live streams all day long. If people want it and people keep contributing and make it worth it, then yeah, hell yeah. I'll just do news. We'll do videos. We'll do interludes, you know, commercials, music video reactions. Who gives a shit? I'll just be playing in your ear while you work. Because this is, after all, my job. But as long as we keep doing it, I'm going to be making the Steve Oatley website different. So you'll see we'll have all the clothes and the apparel and stuff for all the shows that we have. All the coffee will link over to gratiscafe.com. And then here's the best part. All of those links that were up that haven't been working. All those links, I'm hearing beeping. Someone's backing up somewhere. But all of those links for the mystery mugs, those are going to go to special pages that I will do this week with, you know, like important morning news, or like maybe I'll do a 20-minute news show exclusively for the people who get those mugs. And what I may do is combine all the links, right? And so once a month I'll do a mystery mug where it's got a special design and a QR code, and maybe whoever gets that will be like being a member, you know what I mean, for that month. And so you'll get morning news every week. You'll get all that stuff. Yeah, see, I can make this good. Someone said about 20 minutes until court resumes. Yep. Gummo said, Steve, you're telling me your job isn't to look pretty and smile at the camera? No, it's not. Nope. And that's what I was saying to someone the other day. I said, the reason why I've been covering the trial so much and it's working is because you guys have been supporting the channel. So I've been able to do it and not have to like go crazy somewhere else. Fortress America 1776 wants to fight. Hey, I'm all for it, buddy. 172 Emboden Drive, Suite 19, Winchester, Virginia. Come on. Charity match, though. We'll put on box. I got a big-ass warehouse in the backs. I'll set up cameras. We'll put on boxing gloves, and I'll beat the shit out of you. Like, seriously. You know what I mean? Someone said you suck at the pretty part. I do. I really need to, like, shave my head, trim the nose hair, trim the beard. I'm looking fucking haggard right now. I feel haggard, to be completely honest. I feel haggard right now. We'll get it. You know what I mean? We'll get it. Did Biden really create 10 million jobs? Yeah, when you take away 9.7 million. We lost 9.7 million because of COVID. So he could say that he put back 10 million jobs, but not really, because he's saying he's added 10 million jobs. So that would be false, because we put back jobs that were lost because of COVID. But get the Chad beard. I don't even know what that is. A man is never pretty. He can be handsome, though, said Fritz's 7th dad just. Fortress America said, haha, man, I'm easily entertained. Yeah, I know. I would love to fight for charity as long as it's a good cause. Yeah. I see, but then you go into this thing, like a lot of the TikTokers are now doing the boxing thing. Plus, I fight dirty. I'll be honest with you. I fight dirty. You know what I mean? Especially like anytime I've ever sparred, when I used to do martial arts and kickboxing and all that, I would lose my temper really quick, and then a spar would turn to a fight virtually every single time. But clearly, I mean, our addresses are public. We don't hide from anybody. We have haters all over the place, but at the store, we've got non-lethal. I always have lethal with me, so someone would be stupid. They've tried in the past, but my neighbor was the one that sprawled them out. I didn't even get to. So, and then we caught the guy by the air conditioner. Besides that, and I have no idea if those were even anything to do with the show. Well, I know the people that were caught by the police in their car were because of the show, but other than that. Ray asked when they're coming back. So this hearing is going to begin any moment now. They're actually running late. The trial is going to resume at 2:00 Eastern time. They're not really going to do anything. Now they're going to run over, I think, the jury instructions, right? Or right? Because the evidentiary period is now over. So today is like paperwork. They're going to argue stuff back and forth, but in all reality, they keep muting Darrell Brooks because he's being, a pain in the ass. So they keep muting him. So his voice isn't even there. And to be honest, the last hour of that conversation kind of annoyed me because at least if you're televising it, make it public so he can make an ass of himself. You know what I mean? Nanner said, can I get the PayPal? Yeah, it's right there on the bottom of your screen over there. It's live at freightbrokerlive.com. Put a box in front of your face and it's Darrell. Yeah. There was a guy the other day that had, he was on I guess it was a Halloween costume. He was on a subway train and he had a microwave on his head and he opened it. Said, stop filming me. And then closed it. I think it was on TikTok or something, but I was like, that is hilarious. That was funny. I don't care who you are right there. That's funny. Major update from the White House. We are clueless. That is all. Is that? I wonder if today there's going to be a White House press conference. I'll check over on this screen. UPS should be picking up those cookies. And so just to keep in mind, like one of you who ordered California, the reason why you have a 2-day air is because I couldn't afford it. It was $106, which is stupid for 1 pound of cookies or 2 pounds of cookies. My wife made the other ones because one of you guys bought me a box and I didn't know that. But my wife actually made the second batch of those cookies and they were good because they didn't get burnt because I burnt them because when I made the first batch, because I can't cook worth a shit, right? Hot dogs, macaroni and cheese with ketchup. I can do that. I know the ketchup may gross you out. And then macaroni and cheese, tuna fish, French cut green beans, boom. And I could make a burger, but I can't make like the best burger. The wedding that we went to 2 weeks ago, that guy, whose name is also Steve, go figure that one. But he makes the best burgers I've ever had in my life. They're also like $50 burgers, each one, because they are 3 types of beef that the butchers don't like to do it because it's so expensive and they call it ruining the meat. But it's 3 types of beef. And then you ground them all and then you mix, or it's like steak and shit and you ground it all. Oh God, it's so good. And then they piss me off because they're so rich that they make that for their dogs. I'm not joking. It pissed me off because it was the best burger. They eat it, but when they make the burgers for themselves, they also make their dogs these burgers. We did it once. It cost us $44 and we got 4 burgers out of it with the actual meat. $44 and we got 4 burgers out of it. And so yeah, their dogs, their dogs are crazy. These people are rich. They make this car. I'm not going to say what brand, but they made this car that was like a limited edition thing and they numbered them and there was only 10 of them and he's got number 3. It's got 250 miles on it. His daily driver is like a $250,000 Porsche. The wife's daily driver is a G-Wagon. They're such nice people though. Like I was telling my wife after the wedding, I'm like, I want to hang out with these people more. Like we're so out of place with them because they're all wealthy. But you could tell like everybody at this wedding was the night. Well, there was one person that wasn't really 2 people. One was, he's like, yeah, we're not Republican at all. And I'm like, okay, buddy. Like, I don't give a shit. Cause everyone's like, what do you do? And I'm like, I'm a conservative commentator. And they're like, oh, awesome. And then another person, I start talking about politics and he's like, we're very active in the changing the names activities in Virginia. And I'm like, fuck you. Changing the names of schools and tear down statues. I'm like, you're just some, whatever. Nice guy, super nice guy, but just politically dead inside, but really, really nice people, man. And like I said, I was telling my wife, I'm like, I want to be friends with all of them. Not because they're all stupid rich. No, because they're just nice. They don't have that. Maybe you call it like, when you go, I don't know. You could tell because I was bitching about having to spend $56 on breakfast on 2 eggs, a piece of toast, sausage, apple juice, or orange juice and coffee. I was bitching to them about it and they're like, peasant. Like that's what I felt like they were saying, peasant. You know what I mean? Because I was bitching. It was a great breakfast, but dude, no, hell, fuck no. $56 for 2 fucking eggs, and that's one sausage link. They don't even give you 2. It's 1 sausage link. But damn, it was good sausage too. And the eggs were what do you call it? Fair, not free trade, fair trade, like from the farm. Like the chicken like ate it out, and then some servant ran it over to the kitchen so they could, that's the kind of thing. But they're really nice people, really nice people. We'll have to see. Oh yeah, that's what I was looking up. The White House, free range. There you go. I was thinking about asking Quincy if he wanted to come on the show tonight and talk about the violence that occurred yesterday in Eugene, Oregon. But I'm not quite sure if I'm even going to do a show tonight. Biden is going to speak at the
economy from the
he's
bottom
speaking
up,
right now.
giving everyone a fair chance.
Oh, fuck.
When
I don't
we
want
do
to listen
that,
to him.
everybody does well. The poor have a ladder up, the middle class gets ahead.
No, he just lies. I don't care. I want to hear what this thing. My guess is it's Russia. We should do a poll. Like, who do you think that Merrick Garland is going to impugn? Do you think it's going to be Russia? Impugn, wrong word probably. But do you think he's going to say it's Russia, Saudi Arabia, Iran, North Korea? It's going to be one of those countries, or someone that's in close ties with him that did something with our midterm elections. That's what they're going to do. I can almost guarantee it. Wouldn't it be awesome if he indicted, if he indicted President Biden? It should be a crime when you're given an interview to fall asleep on television. Wouldn't that be amazing? Someone said he's going to blame Trump. Of course, see, here's the thing. If they want to be taken seriously, they should not blame Trump. Because in all reality, anything that you try to blame on Donald Trump right now is going to lead me and several other million people to just be like, okay, they're just blaming Donald Trump. They need to lay off, even if you don't like him, like even if the mainstream media narrative is still anti-Trump the fact that they are blaming that guy for everything makes it so that anything he is responsible for, nobody fucking cares anymore. You know what I mean? Because you don't even know what's true or not. That's my opinion. I was having another conversation with, so the press briefing's at 3:00. I was having another conversation with one of those rich people too, that was diehard Trump. He's like, man, Trump gets indicted, I'm going out into the streets. I'm like, bullshit. I'm like, where'd you go to high school? He's like, I went to the best private high school in America. I'm like, yeah, no shit. You're not going to be on the streets. When's the last time you went to a Trump rally? Oh, I've never been to a Trump rally. Shut the fuck up then. Like super nice person. He's probably watching this right now being like, what the fuck? But don't say you're going to jump out in the streets, because that shit ain't happening. You know it just as well as I do. Ask Quincy about people not going out in the streets. Like that dude has he said it so many times. He's like, people don't show up anymore. And then when they do show up, they retreat. And technically they weren't retreating. See, I shouldn't even talk about that. But technically they weren't retreating. They were being the bigger people and going home. But obviously everyone portrayed that as retreating. Crazy stuff, man. Someone said, I'm going to miss the Darrell Brooks trial when it's over. I've never seen anything more insane, but also interesting. Yeah, I've never seen anything like this either. Someone said they are imprisoning Bannon, so it's not far reach to think they'll arrest Trump. If they do, it would be first blood, someone says. Yeah. Jamie something said, Steve Oatley, today in Chesapeake, Virginia, we had 4 high schools with bomb threats and 1 canceled classes. The local news actually blamed Russia. I would be curious to see how that would, how that's actually portrayed. I bet the calls originated from Russia, because people do that all the time. You can route your phone calls. Let me look. Chesapeake. What did I just type? I can't type anymore. Wow. Class is canceled after another bomb threat. Blah, 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 blah. This is October 24th. Is that today? Yes. This includes Deep Creek High School, Indian River High School, Oscar Smith High School, and Western Branch High School, all in Chesapeake. Deep Creek ended up canceling classes for the rest of the day Monday morning after getting a second bomb threat in the past week. The school was searched and nothing was found. An anonymous caller contacted Deep Creek with the threat around 8:10 a.m. Wednesday morning, and a statement of the incident was sent to parents at 9:45. That is way too long. An hour and 35 minutes took them to notice or to say, fuck that, dude. That's why I hate public school. If there's a bomb threat at my school, I want to be the second person called. The first one, the police. But seriously, an hour and 35 minutes for bomb threats is bullshit. Boom, 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 boom. Yeah, see? 2 new investigations published by Wired and NPR on Monday detail how an individual or group who are likely overseas use internet-based calling services to anonymously call in the hoax threats. The exact reason, blah, blah, blah. State law enforcement agents suggested to Wired that Russia could have been involved, as Russia was allegedly behind thousands of fake bomb threats targeting schools and critical infrastructure in Ukraine before it invaded on February. Holy fuck. So this WAVY, so Wavy 10, local news in Chesapeake, Virginia, is insinuating that the bomb threats that are being called into the schools are coming from Russia because allegedly, according to Wired, a news organization, the FBI or because a state, it's not even the FBI, it's a state law enforcement agent suggested to Wired that Russians could be involved, as Russia was allegedly behind thousands of fake bomb threats targeting schools and infrastructure. Anyway.
Good afternoon. This is your 2-minute warning. Attorney General Merrick Garland, Deputy Attorney General Lisa Monaco, FBI Director Christopher Wray, and Assistant Attorney General for National Security Matthew Olson will deliver remarks.
Oh shit, this is going to be a big one.
Also here on the stage will be Assistant Attorney General for the Eastern District of New York, Alexander Solomon, as well as Assistant Attorney General Assistant U.S. Attorney.
I don't care that the trial's back. We're watching this. This now that I hear everyone that's going to be there, this is a bigger deal than the trial. We'll switch back to the trial immediately following this press conference. Okay. I could do a picture. No, I can't do a picture in picture. So he's back in the courtroom and it's just silent. I think this is more important. I'm going to watch this. Yeah, you know what? Denise in Virginia said Trump. That is exactly what I thought. When they said when Christopher Wray is going to be there, the New York Attorney General, the Attorney General for the District of New York, and the Attorney General from the District of New Jersey, that made me think that it has something to do with Trump. Oh, fuck, shit. What did I do? Oh, gosh. Oh, man. Turn off captioning. Isn't Trump being sued in Southern New York? Does that rule him out? No, this is Southern. So he's being sued by Attorney General, New York's Attorney General, but that's a state Attorney General, Letitia James. She's going after everyone. She's going after the company that sued me for $5.5 million, Nexus Services, where all of their executives, all but one, have been indicted on either state or federal charges. Not to say it's because of my reporting, but got him. And I can't wait till they're all sentenced because I'm going to serve them with their anti-SLAPP lawsuit as they get sentenced to years in jail. It's going to be amazing. It's going to be amazing. But yeah, this is bigger than I thought, because I thought it was just going to be Merrick Garland coming out and saying something very quick. But if he's coming out with the FBI director, Christopher Wray, whoever the other woman is that he said, in addition to the New York, the U.S. attorney for New York, for the District of New York, and the U.S. attorney here.
Good afternoon. I'm joined today by Deputy Attorney General Monaco, FBI Director Wray, and Assistant Attorney General Olson. Also here are Assistant United States Attorneys from the Eastern District of New York and the District of New Jersey. Over the past week, the Justice Department has taken several actions to disrupt criminal activity by individuals working on behalf of the government of the People's Republic of China. As always, the defendants in these cases are presumed innocent until proven guilty in a court of law. Earlier today, in the Eastern District of New York, a complaint was unsealed charging 2 PRC intelligence officers with attempting to obstruct, influence, and impede a criminal prosecution of a PRC-based telecommunications company. The complaint alleges that in 2019, the defendants directed an employee at a U.S. government law enforcement agency to steal confidential information about the United States criminal prosecution of the company. The defendants believed that they had recruited the U.S. employee as an asset, but in fact, the individual they recruited was actually a double agent working on behalf of the FBI. As the complaint alleges, the defendants paid a bribe to the double agent to obtain non-public information, including files from the U.S. Attorney's Office in the Eastern District. They did so in the hope of obtaining the prosecution's strategy memo, confidential information regarding witnesses, trial evidence, and potential new charges to be brought against the company. The double agent provided the defendants with documents that appeared to present some of the information they sought. In fact, the documents were prepared by the U.S. government for the purpose of this investigation and did not reveal actual meetings, communications, or strategies. This was an egregious attempt by PRC intelligence officers to shield a PRC-based company from accountability and to undermine the integrity of our judicial system. Also earlier today, in the District of New Jersey, an indictment was unsealed charging 4 individuals, including 3 PRC intelligence officers, with conspiring to act in the United States as illegal agents on behalf of a foreign government. The indictment alleges that between 2008 and 2018, the defendants used the cover of a purported Chinese academic institute to target, co-opt, and direct individuals in the United States to further the PRC's intelligence mission. Those directives included attempts to procure technology and equipment from the United States and to have it shipped to China. They also included attempts to stop protected First Amendment activities, protests here in the United States, which would have been embarrassing to the Chinese government. Separately, in the Eastern District of New York, the Justice Department charged 7 individuals who were working on behalf of the PRC with engaging in a multi-year campaign of threats and harassment to force a U.S. resident to return to China. Last Thursday, we arrested 2 of those defendants. Those activities were part of the PRC's global extra-legal effort known as Operation Fox Hunt. Its purpose is to locate and bring back to China.
All right, are you guys good on this? Or you want to keep watching this? Press 1 for this, 2 to go over to the trial. Let's go.
The PRC has a history of targeting political dissidents and critics of the government who have sought relief and refuge in other countries. The indictment alleges that the defendants, working at the direction of the government of the PRC, engaged in a campaign of harassment, threats, surveillance, and intimidation aimed at coercing the victim to return to China. We also allege that the defendants threatened and harassed the victim's family members, both in the U.S. and in China. The PRC government forced the victim's nephew to travel from China to the United States to convey the PRC's threats to the victim's son. The defendants threatened the victim, saying that, quote, coming back and turning herself in is the only way out. They showed up at the home of the victim's son in New York. They filed frivolous lawsuits against the victim and his son and said it would be, quote, endless misery for the defendant and son to defend themselves. And they made clear that their harassment would not stop until the victim returned to China.
All right, we are back on the record. It is 1:01 p.m. State versus Brooks. Appearances are as they were before. I would note I have instructed, and Mr. Brooks is present in this courtroom. Prior to the I understand your objections
I don't
noted.
want to be in this courtroom.
If you would like to go back to the other courtroom, sir, you may, but that is a choice that you would be making. I am not requiring you, I'm not forcing you at this time.
So you're not holding me in contempt?
Sir, I am not requiring you or forcing you to go into the other courtroom. It is a new part of the day. I thought it appropriate to have you brought here.
Why?
And only if you forfeit your right by conduct will I put you back in the other room.
So you going to address subject matter jurisdiction for the record? Or are you going to state it on the record?
I'm declining to address that on the record for the reasons I've previously provided to you, not the least of which is I have addressed that by way of a written decision.
And it hasn't been proven for the record. You
Your
have to state
objection
it
is
on the
noted.
record. Can I go back in the other courtroom? Because I'm not finna do this with you. I'm not.
Mr. Brooks, I do want to go over
We don't
the
have.
jury instructions.
I don't understand the
verdicts.
jury instructions. I don't understand anything that's in these proceedings, and I'm not going to participate in something that I don't understand.
That's your choice, sir.
May I please go back into the other courtroom?
You can, based upon your choice and your request, I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything. I asked.
I understand you've
So
asked, but
I
I
didn't
feel it's
forfeit
important to
anything.
also make a finding based upon your conduct.
Based upon what kind of me asking?
Are you willing to expressly waive that right on the record right now?
I'm not gonna expressively waive anything.
Are you willing to
I'm making
engage in a colloquy regarding your right to be present
I
and a
do not.
knowing and intelligent and voluntary waiver of that right?
I am not going to consent to anything that I don't understand, and I will not answer any questions that I don't understand. I'm merely making a request to not be present in these proceedings.
And to be in the other courtroom?
Again, as I've stated numerous times now for the record, I will not answer or comply with anything I do not understand. I'm not making a voluntary waivery of anything.
Are you willing to be, let me rephrase that. If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking.
Are you willing to not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking.
Well, given that he won't answer the questions directly, for now he is to remain in this courtroom.
I'm requesting to not be in this courtroom.
But you won't go through, you won't answer my questions regarding that, sir.
I did. I told you I don't understand.
That's not answering the question, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand, Your Honor?
All right, let me start with the jury instruction.
You'll
There
start
is
with,
one I
you'll
would
start
like
with subject
to.
matter jurisdiction?
No, I've declined that already, sir. I'm not gonna address that
Under what
further.
law, under what lawful law?
Sir, please do not interrupt me again with the topic of subject matter jurisdiction, or you run the risk of forfeiting your right to be present in this courtroom.
Then let me go in the other courtroom then.
Are you willing to engage in a discussion about that, sir? I need to make an appropriate record.
I just told you that I don't understand the questions you're asking. What do you want me to do? I can't answer something I don't understand.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so.
Your
But it
rights
doesn't
are not
matter what we
unfettered,
believe,
sir.
Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the
Sir,
questions you are asking me because
It
I
seems to
don't
me
understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand
that
anything.
right?
Nope. I don't understand. Nope.
Then you're gonna stay here. For now.
And under what lawful law? You
got him.
you can't force me to stay somewhere that I'm making a request not to.
So get up and be a
You
tough guy.
You can't make me understand. You can't make me. You can't force me to understand what I don't understand.
You can't make me stay.
I need to address one of the jury instructions, number 315.
So, Your Honor, I'm trying to make a request to not be present in these matters without disrupting the courtroom, as you say that I do.
He has to do a colloquy. A colloquy.
A request merely to not be present for these proceedings.
Tough shit.
Obviously, I'm not needed because every decision that's been made here today has been made without my consent. That's clearly telling me that I'm not needed. I have never consented to anything that's going on here today.
You know who
also can't be present in that courtroom as he's putting this stupid shit on his victims.
You already knew, Your Honor,
He
that I
should stay in
wanted
that
things
courtroom
to present into evidence. I've asked numerous times for that and have been denied. And I don't understand why I'm not being able to adequately defend myself.
In your words, you're not being allowed to adequately defend yourself based upon your conduct in this courtroom and throughout these proceedings, and your unwillingness to follow the simple rules of decorum, courtesy, procedure, rules of evidence. You refused to answer a variety of questions this morning when this court went through or attempted to go through the colloquy with you regarding your right to testify, and your right not to testify.
Get him.
And because of that, and based on the case law that I cited this morning, I made a finding that you forfeited your right to present further testimony and evidence through other witnesses, and then you forfeited your right to testify in your behalf. I'm not going to revisit those, sir.
I'm not asking you to revisit them, but I'm just they weren't correct.
I understand you will
because
disagree
I
with
never
that.
consented to it and I never answered something.
I understand
and
you
I
did
just
not
stated
consent
the
to
reason why I didn't answer because I don't understand. You cannot force me to understand what you're asking me.
Sir, I could not even get through the advisement. You wouldn't even listen. You talked over me repeatedly.
Was that from the other courtroom or in here? Because I've been over there all morning.
To the place that you are requesting to go back to, right?
You sent me into the other courtroom.
You're right, I did.
Right. So I've been over there all morning.
With an adequate audio and visual system connecting the two courtrooms. A functional equivalent
to
of being
your
present in this
equivalent
courtroom.
to your equivalent is adequate, but to mine it's not. Seeing as how you always state Illinois versus Allen. You always state that. But it never refers to a fourth option that you refer to. It never
Mr.
refers
Brooks, I'm not
to
going to
that.
debate this with you. If you continue to bring up subject matter jurisdiction, Illinois
I
versus
didn't bring up
Allen,
subject
the
matter
decisions that I
jurisdiction.
made earlier,
I'm trying to figure out why I'm being held in
you are
contempt.
frustrating the purposes of this hearing
I'm trying to
right
figure out
now,
why I'm being held
which
in
is to
contempt.
finalize the
And
jury
then when I-
instruction and the verdict forms.
Your Honor, I'm merely trying to understand why when you hold me in contempt,
I never held you in contempt, sir.
you attempted to.
Nope.
You've never attempted to hold me in contempt.
No, sir. I'm not going to revisit all of these issues.
When I asked you where you hold
Are
me in
you
contempt,
going
you
to
said civil.
respect the decisions that I've made?
They're
by
not
not interrupting
They're
me?
not correct decisions, Your Honor.
I understand that.
I can't answer. You asked me questions. You asked me questions. I didn't answer them based on my understanding. How can you force me to understand what you're asking me if I don't? And then you still make a finding based on that. How is that lawful law?
Mr. Brooks, I stand behind the record that I've made today.
And that's fine. I'm not
advising you
arguing
that
with
if
you
you
about what you
continue
rude.
to talk
I'm saying
over
how
me,
can you do that without my
if
consent?
you continue to raise issues that I've
That's
already
a violation
addressed,
of my civil rights.
if you continue to raise these issues, sir, and thwart the purpose of this court, which is to finalize the jury instruction and the verdict forms, you will forfeit your right to be present in the courtroom, and you will appear from the other courtroom.
Okay.
Absent you, I know
And
you've requested to be there.
I made a request the moment we walked in here to not be present for these proceedings, but yet
But you
still
also won't have a dialogue with me about your understanding
because
of
it's
what that
my
means.
Fifth Amendment right. I'm exercising my rights that I reserved from the moment we walked in here this morning. You can't force that. You can't force me to do anything, actually.
No, you're right, but I can make certain findings that you forfeit rights
You
that
can't.
you have based upon your
and based
conduct.
on what lawful law, Your Honor?
I've cited the law this morning. All right, I am moving
Illinois
on.
versus Allen, right?
I am moving
That I can
on.
be present from another courtroom.
I need
if I
to
forfeit
discuss
my right-
instruction 315.
Your Honor,
because
I don't
believe some language
understand.
needs to be modified based upon the court's earlier ruling today.
I don't understand. I don't understand the proceedings. And I think that should be stated for the record. If I'm telling you repeatedly, Your Honor, that I don't understand. You can't force me to understand. That's a violation of my constitutional rights to try to force something upon me. That's coercion, Your Honor.
Mr. Brooks, I completely disagree with your characterization of the proceedings this morning. While it is true that you did not provide consent, you were entirely uncooperative with court this morning.
That's because I didn't understand. I'm explaining why, Your Honor. I'm not trying to leave it where it was at. I'm attempting to
answer the questions.
I'm attempting to
So I'm going to go
explain myself of why I did not answer. It was because the way that you're making it seem is that I intentionally didn't want to answer, and that's
Mr.
not
Brooks,
fair.
I'm moving on to instruction 315.
And I still don't understand. So how can we even proceed?
Mr. Brooks,
if I'm telling you I don't
understand what that I'm asking you to be
No,
quiet?
I don't. No, I don't.
Mr. Brooks, please stop interrupting
And for the
me.
record, I don't consent to being called that name, Your
You
Honor.
clearly hear me, sir, because if you didn't hear me,
Too bad,
you
that's
wouldn't
your
make that
fucking
statement.
name.
Hearing
Here's
and
your
understanding
ID,
is two different
shithead.
things.
I know you can hear me, sir. I'm asking
Hearing
you
and
to
understanding
stop
is two different
interrupting
things.
me.
I'm not trying to.
She's gonna
interrupt
kick
you,
him
but
out
you're
in
gonna,
3.
At some point, you're gonna ask me my opinion of what's going
2.
on, and then when I tell you I don't understand, it's gonna be taken as me
2.
trying to delay or trying
If
to do
you
this or
stop
trying to do
talking,
that.
I will explain
2.
why I'm bringing up instruction 315.
And I'm not gonna understand your
2.5.
explanation.
You can't say that if you haven't heard what I have to say.
Didn't you try to do this
1.9.
earlier before lunch?
Shut the
But
fuck
I
up,
need to
Darrell
clarify
Brooks. We're trying to
something,
get rid
because
of you.
315, which is the instruction that has it's titled "Defendant elects not to testify." I had it in there. However, that instruction should really only be given if requested by the defendant. There has been no request made. And obviously this court made a finding that he forfeited his right to testify. And absent Mr. Brooks requesting that instruction to be in, I believe it would not be proper for this court to include 315 in the instructions to the jury. Does the state have any position on that?
Your Honor, I did look at the notes that are associated with instruction 315, and I would agree.
Mr. Brooks, do you have any position on whether this court should include instruction 315 in the jury instructions to the jury?
I don't even understand what 315 jury instruction is.
It's
I don't-
entitled "Defendant elects not to testify." I'll read it for you. It's my notes, meaning my materials, my jury instruction book says to be given only if requested by a defendant, and it reads as follows. This is the actual language of the instruction. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. So my question is, do you want this instruction read or modified in any way?
You just said I got a constitutional right not to testify or to testify. I didn't make either one of those decisions, so I don't understand.
The
what you're
jury
asking.
instruction is typically read when a defendant does not testify. In every other case that I've had, the decision on whether to testify was a decision made by the defendant personally. In this case, the court found that you forfeited your right to testify based upon your conduct. That is the ruling I made this morning.
How did I make that decision though? I didn't.
My question to
never say
you
yes or no.
is,
I never
do
say
you
yes or
want
no.
the jury instructed that your silence must not be considered by them in any way and must not influence their verdict in any manner?
What do you mean my silence? My Fifth Amendment right?
Correct. I'm not hearing a request from you to have the jury
Because I
given
don't.
this
I
instruction.
don't understand why you're asking me the question, Your Honor. I never decided to or not to testify. I never
understand
decided
that,
either
sir.
way.
I understand that.
So how can I answer that? I don't understand why. I don't understand.
we are now at the moment where we are discussing whether the jury should receive an instruction specifically on you not testifying, irrespective of the reason for that. I believe I could modify this instruction to simply say a defendant's silence or a defendant not testifying should not be considered by the jury in any way and must not influence their verdict in any manner. Are you making such a request for a modified instruction?
I don't understand the question because I never decided to or not to testify.
I understand. I understand what you're saying, sir. I really do. But in light of the court's decision that you forfeited your right to testify,
how did I forfeit something I never said?
Do you want the jury to be instructed something to the effect of they cannot use your silence, meaning they cannot use you not testifying against you in any way?
I don't understand because I never made a decision not to or to testify.
I'll ask you one more time, and if you do not answer with a yes or no, I will take your answer of not answering as you are not making a request for a modified instruction.
How can you do that,
Do you want this court, sir, to
because she's a
instruct the jury
fucking
in any
gangster
way regarding you not testifying in this case?
I don't understand the question.
Yes,
All
you
right,
do,
then
bitch.
based upon there's not been an express
Get him, Judge. Enough of
request
this
made
shit.
by Mr. Brooks to give either 315 as it's in the standard or pattern jury instruction or a modification as this court has suggested.
Hell yeah.
315 is to be taken out of the jury instructions.
Take that, bitch,
How are all
out.
these decisions being made without me understanding?
Because she's a gangster.
Then I have looked over the verdict forms, and other than really what I would describe as some consistency in how phrases, whether there's all caps, not all caps, but what we call the sentence capitalization for the charges.
She's a gangster.
For example, I want to be consistent with how I spell out first degree intentional homicide or first degree recklessly endangering safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through all of that to be consistent. I want to make sure the word information is capitalized since that's the charging document, things of that nature. It is my practice, and you should be aware, Mr. Brooks, that I always put the not guilty verdicts on top when I hand all the verdict forms to the jury. And by that, I mean it's by charge. So they're collated, if you will. So the not guilty followed by the guilty for counts 1 through 76.
You said it's collated. What do that mean?
Oh, shut the fuck up.
So
You know
I
what
put
that
the
means.
not guilty, then the guilty for count 1, followed by the not guilty and the guilty for count 2, and so on and so forth, all the way through the remainder of the counts that are alleged in this case, which in this case total 76.
I don't understand. So how?
I looked at the special questions
Will you
that
answer
are
that, Your
on the
Honor?
guilty verdicts only. They did appear to be proper. Again, just some grammatical things, but I believe those are all accurate.
Can I go to the other courtroom?
state.
Since you don't have to answer any questions, but I have to answer all, can I just go to the other courtroom?
Not at this time.
Why not? I keep telling you I don't understand these proceedings, and you just keep running right over my rights, like you don't even hear me saying anything.
Attorney Basie, are you handling the verdict forms? Yeah. Go ahead.
Can I go to the other courtroom, please?
Are you waiving your right to be present in this
I'm
courtroom?
not waiving anything.
Then the answer is no.
I'm making a request.
The answer is fuck no.
Then how's it? So what? You gonna try to force me to interrupt and do all this so you
I'm
can
not
make the
forcing you,
record
sir. I'd
and
like
make
you
it
to be
seem like
here.
I forfeited something that I came in here as soon as we got on the record and made a request to not be present for these proceedings. But when I'm making a request to avoid the drama and all that,
Sir, the only one with the drama is you.
Yeah.
it's you too.
Oh,
You're the
shit.
big contributor to the whole thing.
Mr. Brooks, I have to preside over this case. I
Yeah,
have
and you
to
haven't
make
been
determinations.
impartial or fair yet.
My gosh.
Mr. Brooks, I have a question to the state. I ask that you not interrupt, and then
It's not about me
response.
interrupting. It's about me attempting to understand. I've been saying that since we came in here.
Mr. Brooks, I
You
will.
can't
I will
force
respond
me to
as follows
understand.
to that. You waived your right to counsel.
I didn't waive my right to no counsel.
We all
I
heard
gave
it,
you the contract.
bitch. Right.
I did not.
Yes, you
And you
did.
won't sit here and say that for the record because that is not
No,
what happened.
you are
No.
incorrect.
So we don't have the. Do we have the
In your-
paperwork?
Your
Because I
mom
believe
did, but
that
you
I
wouldn't
gave
let
you
her
the
testify,
paperwork back. That
bitch.
you,
Mr. Brooks, you very
I gave it to you, altered.
clearly
It did not waive it.
have been presenting a nuanced argument regarding
That
the
is
right
not true,
to
Your Honor.
counsel
That is not
versus
true.
the right to assistance of counsel.
That is not true.
That's a pretty sophisticated argument. That's why I believe you fully understand what's
I
going
don't.
on in this
he does.
courtroom.
I don't fully understand.
I disagree with your characterization
I disagree with
Get
your
him, Judge.
of the
characteristic.
right to counsel.
You know that you accepted
You
the way that I
waived
gave it to
the
you.
entirety-
So you shouldn't have did that if you had questions of me not understanding.
I don't have any questions whatsoever.
You definitely do, because I'm telling you right now I don't understand, and you still won't even acknowledge the fact that I'm saying
'Cause you're
in open court on the record that I don't
full of
understand something. I haven't waived anything. You made decisions today that I didn't consent to, that I explained I did not answer because I didn't understand, which is my right to say that.
All right, Mr. Brooks, you
It is
are
also my Fifth
interfering
Amendment
with the
right to be
proper and
silent.
orderly administration of these proceedings. I understand that you disagree with the decisions that I have made, but you aren't respectful of the decisions. You keep wanting to debate them and argue them. That is not the proper legal recourse at this time. I have asked you if you're willing to waive your right to be present. You indicated you're not.
Because
And yet
of the way
you continue to
You said
interrupt.
waive. I'm not waiving anything.
Then that's why you're here until I make a finding that you, by your conduct, are forfeiting your right to be present.
Well, make the finding and kick me out.
Shut the
Make the
fuck
finding and
up,
hold me in
Darrell,
contempt.
shithead, bro.
Which is what you waiting to do anyway.
It's
That's
just
why
what
that
you
courtroom
do
is set up the way it
anyway.
has for the whole time. Because at some point it's anticipated that I will be over there. Which is not impartial and which is biased. It's judicial misconduct.
Your face is judicial misconduct.
I stated from the beginning, sir, that the goals of this trial.
So you reading from
Are
the paper, or
threefold.
are you reading, or are you just citing what
Number
you know?
one,
Are
sir,
you reading from the heart,
is
ma'am?
during the evidentiary phase of this was to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process.
And I offered
That
evidence that you didn't allow.
developing relevant facts upon which a determination of guilt or innocence can be made. What is sometimes referred to in the case law as the ascertainment of truth.
Ass.
There's an
She said
equal
ass.
but secondary purpose related to efficiency and effectiveness. That has been my repeated use of 906.11 is what that would fall under. There's a third goal of everything that I've done here, and that is the courtesy and decorum in this courtroom, what I sometimes refer to as civility. Of course, there are other goals as well, including protecting your rights, protecting the record, protecting the jurors.
How have my rights been protected, Your Honor, if I can't even put evidence into
Disagreement
it?
with the
I can't
court
even make evidence.
decisions, sir.
Yeah, but how can
In
I defend myself if I can't even present evidence?
But sir, you have not been willing to follow the rules of civility and
But that doesn't
decorum
have
and
anything
trier.
to do with my evidence.
It has
I could have
everything.
did that from the other courtroom too, correct?
Sir, you.
If I can
by
be
your
present from the
conduct-
other courtroom, I should be able to present evidence from the other courtroom as well.
And you, by your conduct this morning, sir, are
I'm
not
saying-
willing to
I'm
answer
saying-
the
I'm
most
saying
basic of
totality.
questions
The
about
totality, Your
whether
Honor. The
you
totality. Have I not asked? Have I not asked? In fairness, have I not asked to admit evidence? Have I not asked more than once?
Mr. Brooks, you have not asked to present any evidence.
Yes, I
in a
have.
legally
You told me we weren't at the
cognizable
evidentiary phase.
manner.
How would I know
Mom
that if
isn't
you
at the
didn't
evidentiary
answer
And you,
the question?
as your own attorney, you proceed at your own peril sometimes.
At your
That
Whether
has
you have
nothing
a
to
full
do with
understanding of the
presenting
rules of
evidence.
procedure and rules of evidence or not. And
That
I
has
made that
nothing to do with
abundantly
me being able to
clear.
present evidence.
So, Mr. Brooks,
Nothing I
this is your
nothing I
final
presented have
warning.
been able to be admitted into
I am turning
evidence.
to the state for a discussion of the verdict forms. If you interrupt me or them again, then I will make a finding that you forfeited your right to be present.
Make the finding.
And you will appear from the neighboring courtroom.
You want me to appear from the neighboring courtroom?
I don't.
Just let me go.
Attorney Basie, go ahead.
Just let me go.
I felt that all the verdict forms looked good. I did ask your clerk.
All right, he's interrupted. He's forfeited his right to be here. He's chosen to do that despite the warning from the court. Will be in recess until
warning. I'm the one that asked.
Over
let's
to the other
make the record
courtroom,
correct.
and we
I'm
have
the one
the
that asked
audio
when we came in here, Your
and
Honor.
video working appropriately.
I asked when we came in here to
Madam
be
Clerk,
present
we'll
from the
have
other
to do it by
court.
Zoom because we may have to utilize the share screen in order.
We don't have to utilize no serious screen because I'm not going to participate in no proceedings that I don't
The
understand.
documents.
I told you I don't understand
We're
a
in
million
recess until
times.
we get the courtroom set up.
No, we don't have to be in recess. I don't agree to it.
Oh, luckily for you, it doesn't fucking matter, you shithead. You fucking little shit stain. You're the biggest shit stain on the shit stain or shit stainville. Shit stain. Fuck Darrell Brooks. Yeah, 6 life sentences. Here we go now. We're on a break one more time. We're on a break again. Yeah. Darrell Brooks can't act accordingly, so he keeps getting sent to the other courtroom. Darrell Brooks is a shithead. Oh, what? Darrell Brooks is a shithead. Say it again now. Darrell Brooks is a shithead. Yeah, Darrell Brooks is gonna get 6 life sentences. Yeah. Pam Zam said, any way to fix the sound? No. Rhonda said, LOL, had to mute because my boss could hear the cursing. Rhonda, quick, turn up your volume. Rhonda. Wait, no, that's the wrong comment. I meant this one. Rhonda, turn up your volume. Right? I'm going to say hi to your boss. Okay? All right. Yeah, so turn up your volume and then type in the chat when you did it. Okay? All right? All right. Let me know, Rhonda. Let me know. Let me know. Tell me, Rhonda. Type it in the chat, Rhonda. Oh, she's not going to do it. She's not smart. Come on, Rhonda. Come on, Rhonda. All right, let's pretend she did. Hey, Rhonda's boss, she's not working. You should fire her. No, I'm just kidding. Was that too much? Oh, Rhonda's boss, you must give her a raise. Give her a raise right now. Because even though she's not working, clearly, she's watching the most entertaining guy on YouTube right now. I mean, come on, without question. Come on, Rhonda. Here, I'm going to write a song for Rhonda right now. Normally, I reserve the songs for the super chats and the cash apps and all that, but you know what, Rhonda? Oh, yeah, this one's for you. Yeah, Rhonda. Yeah. Rhonda's not working. She's being lazy. Her boss is yelling at her. Rhonda probably works as a secretary, and her boss is sitting there saying, why aren't my shit done? Because Rhonda's too busy watching YouTube. Rhonda's too busy watching YouTube. She's too busy watching the trial. I just saw my reflection. I'm doing the robot. I saw the little preview screen, and I was doing the robot as I sat here in my chair. I'm such a fucking goober sometimes. Damn it, I forgot to place this order. Placed. I'm lazy as shit, so I'm having Walmart to deliver a vacuum to my store. To my office. A vacuum, some Cinnabons for my kid that I'll bring home, some chips so I have something to snack on, some Mountain Dew, and you'll discover that it quenches thirst just like no other. Some labels so I can print some more labels for the coffee, a broom, and a plunger because, my diet makes me take massive shits. They're taking quite a bit longer to come back. Normally they're back already. But uh-oh, is someone mad? Donita. Is Donita mad? Here, Donita, I got a song for you. Ready? Fuck you. Donita. Pinata. I don't know, it kind of rhymes. Donita is a pain in my butt. She gets in the chat and talks shit. But it's okay because her song is gonna make America's Top 40 Countdown. Your mama was even smart up to show Cookie Brook. What? I can't even read your comments. What the fuck? Dorito, Donita, Paquito, Pinata. I don't know what the fuck your name is. I forgot what your name was. Seriously. Was it Dorito? Like Doritos? Like the Doritos? Like those are good. But now you just, Donita, you just ruined Doritos. Like they're like Oreos, dead to me. Like Oreo Express killed Oreos for me. I can't even enjoy one without seeing his fucking face. No, I'm just kidding. I've actually had Oreos since, well, every night for the past 3 nights, and they're very good. Status Quo said, Oatly may be the worst wingman in the world. Yeah, well, I don't go out, so I don't need wingmans. Donita Cantrell said someone said she's, excuse me, Dorito. What's Steve on? Her name was Doriton. Deverton. Love and 2 times said, please share what voice changer you're using. It's called the Rodecaster Pro 2. It's actually got it built in. I could modify it and put like auto-tune shit on it if I really wanted to, and I could put other music instead of just that one, but I don't fucking care. It's just funny. Todd Horton said, I think someone gave Steve crack. Nope, this is just me. You're welcome. I'm glad you're all having fun. Oreos have cricket powder. Yeah, well, I like cricket powder, so fuck off. Cricket powder's good as shit. So how many of you guys have heard of that show, The Blacklist? Right? So I started watching The Blacklist several years ago, and it sucked ass, and I stopped watching it after episode 2. And then, because there's nothing good on television, and we don't actually have, we have YouTube TV, but we don't watch TV except for the news in the morning. Anyway, so I decided to start watching Blacklist 2, or The
Mr.
Blacklist
Brooks is
again.
now
Fuck,
appearing
she's
from
back.
the
You
other
ruined my
courtroom.
story. She ruined my fucking story. Jennifer Doro fucking A did,
To make a
Jennifer.
correction to the record from this morning, I had made a statement that, given his demeanor, the headphones had been taken off the table by the bailiffs. I was incorrect. Mr. Brooks handed the headphones to the bailiff, saying he didn't want to break them. All right, so we are discussing the verdict forms. Go ahead, Attorney Basie, you can complete your record.
All the verdict forms look good. I did notice, and I think it was actually the day that I missed speed. For count 15, I have a not guilty verdict. I did not have a guilty verdict, but the way that it was on the paper made me believe that something happened, and I think you probably have it with your packet. It just didn't get printed off for me.
We'll make sure that that's there. Any misspellings of any names?
I did not see any.
All right. All right, I did, when we started up the video conference, Mr. Brooks has been muted. I am going to unmute him right now. And I should state again for the record, all of the verdict forms, or at least the drafts, were provided to him prior to the lunch break. So he would have had an opportunity to review them should he have chosen to do that. Do you have any position on the verdict form, sir?
I wasn't provided with anything, and if I was, I accepted and returned it for value. And since I'm now in another courtroom, are we going to address subject matter jurisdiction? We have yet to prove it for the record.
Mr. Brooks, you were provided with the verdict forms. What you did with them, I don't know.
Again, I haven't been provided with anything.
They were provided to you prior to lunch, the lunch
I
break.
haven't been provided with anything.
Teresa, you had the large packet of verdict forms. What were they, how were they given to Mr. Brooks prior to the lunch break?
By hand to the bailiff and the bailiff to him.
To be, and the bailiffs are confirming that they.
Hey, guys, real quick, very important message. We
are very far away from our streaming goal today, our financial goal, which we try to do every day. We're pretty damn far away from it. I think in the past 2 weeks, we are the furthest away at this time than we ever have been any other day. So if you want to support our stream so we can keep doing this every day, you can either do Cash App, Venmo, or PayPal, Super Chats on it, however you can do it. Please do, because otherwise I just can't keep doing it. I got to do other shit. So, all right.
Appropriate counts had and have the appropriate special verdict questions. Those special verdict questions are only as they relate to guilty verdicts related to the use of a dangerous weapon for counts 1 through 6, the homicide counts, and then 61 through, I belive 60.
It would be 7 through.
Or 7
Shout
through
out to
60.
Patricia.
Have that special verdict, and then the hit and run counts have the special question related to did each of the counts involve the death of a person, and it names the person alleged to have been killed. So those look to be all in order. I've already addressed going back to the jury instructions 315. We have done a little bit of rearranging some of the order, but the content is there. It is my practice to read through all of the instructions up until the point of closing arguments, and then I stop. Parties are given their opportunity to argue the case to the jury, and then following that, there are what I like to call the closing instructions, or which are still quite lengthy in this case, given that they go through the verdict forms specifically. And then, of course, the alternate jurors would be selected. But given...
Am I muted?
No, you're not. You haven't been.
So I got a question about the hazard for use of a dangerous weapon. How is that being charged? Is that under 939.632?
Thank you, D. And
It is in the charging documents, sir.
Michael, for the Venmos. Thank
How
you.
is that being charged? From my understanding, that the statute reads the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charged. Without the vehicle, there is no crime. So that would apply. So how am I charged with?
State one is your argument only as it relates to counts 1 through 6 or others?
Whichever count has the enhancement penalty for use of a dangerous weapon.
Well, that would be all of the intentional homicide charges and all of the first degree of recklessly endangering safety charges, so counts 1 through 67.
So 1 through 67.
Correct. I can have the state respond to that.
Yeah, how is the alleged defendant being charged?
So are you asking how are you making a specific request as it relates to the special verdict question?
I would say both. Seeing as how I don't understand how.
Thank you, Deborah and Cassie, for the Venmos.
That's why there's the question.
Let's keep it going.
Reading the
We're still pretty
statute.
far away from today's goal.
And which part of this?
About
I'm sorry, which part of the
$150.
statute are you referring to again?
I believe it's 939.632.
And your specific argument is what again?
how is that enhancement, how is the alleged defendant charged with that enhancement when reading the statute, it says it, well, I just read it, so.
I do have Zelle. It's my email, the live at
I believe you're
freightbrokerlive.com.
referring to sub 2, which states the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charged.
Right, that's what I just read, Your Honor.
Well, what's the state's response?
Cash App and Venmo are all on the screen.
Possessing or threatening to use a dangerous weapon
Lower
is
left-hand
not
corner.
an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety.
Oh
If
shit,
it
we're almost
were,
at our goal.
It would be one of the
He's got a
elements
big
in
one.
the standard jury instructions, and the defendant can see it is not. This is different from a situation like armed robbery, which does require the use or threatened use of a dangerous weapon. So the penalty enhancer is correctly charged for those two types of crimes.
Any final argument on that, sir?
Yes, that's not what the statute is clearly saying. It's clearly stated it does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. If there's no vehicle involved, where is the crime? It has to be an essential part of it to even be a crime. The alleged defendant is charged with using a vehicle to commit these crimes. If there's no vehicle, where's the crime?
What?
So it has to be an essential element of the crime. Otherwise, there's no crime.
What?
I think it's the essential element. If you read in the statute, it's the essential element. You can't just walk up to someone and quote unquote run them over. There has to be something used in order for this alleged crime to transpire, and that would essentially mean the quote unquote dangerous weapon. So without the quote unquote dangerous weapon, where's the crime? So how can it be charged when it is the essential element of the crime charge?
Well, sir, I've listened to your argument. I've read the statute. I've looked at the elements for intentional homicide and first-degree recklessly endangering safety. Neither one of those crimes have as an element in it use of a vehicle. There are certainly many different ways that both of those statutes can be violated. While it's true that in this particular case, the use of the vehicle is the mechanism or instrumentality that's being alleged to have been used, but it's not the same as being an essential element of the crime. I think the armed robbery crime is a good example of when you could not face an enhancer for use of a dangerous weapon because you can't have the crime of armed robbery without the threat or use of a dangerous weapon. And so
that's the same argument in this, Your Honor. You can't have this alleged crime without the use of the vehicle. It's the same thing.
it's not an essential element of either first degree intentional homicide or first degree recklessly endangering safety. So I'll deny the request to strike the enhancer for those reasons and find that it is properly before the jury for their determination.
I respectfully object to that, Your Honor.
Understood. Do you have any other challenges to the verdicts you'd like to raise at this time?
Yeah, will my objection to that be noted for the record?
It is.
May I request a legal reconsideration of your ruling, Your Honor?
Denied.
May I request a written finding of fact for your ruling, Your Honor?
Denied.
Denied.
Just for the record, it's my understanding that the verdict forms were put in the garbage by Mr. Brooks and they remain in there. That was provided to me by the bailiffs.
May I respectfully request a written judicial finding of facts and conclusion of law for this issue, Your Honor?
You may not.
You may request it. The request is denied.
Fucking A.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
This is not the proper court to grant such relief.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
Fucking denied,
Based on what
bitch.
law or fact?
The facts.
Your
of
request is not based on
life.
law or fact, sir.
Facts of reality.
I
Facts
just
of
stated-
life.
I just read a statute that it came from. My argument was based on a statute, a Wisconsin statute.
Your request is noted. Your objection to the court's finding and determination is noted. I decline to issue any type of written decision or stay pending appeal, noting there is no appeal that has been filed.
May I let the record show that this court will not allow the accused to adequately defend themselves in this matter?
Court's already made its findings regarding the forfeiture of right to testify and the forfeiture of the right to present additional evidence and testimony.
Which was not-
I'm not going to
which was not
revisit the same.
consented- Which was not consented to. I never stated that I did or did not
Understand.
want to testify.
I understand.
So how can that decision be made on my behalf when I didn't say either way? What I stated was I didn't understand the questions being answered.
Sir, do you have any other questions or issues regarding the verdict forms?
Your Honor, are you making a judicial determination that you don't have to answer any questions?
I'm not answering those questions, sir, other than how I've already answered them.
Is that a judicial determination?
Sir, every decision I make is a determination by this court.
Is it a judicial determination?
Sir, I will ask you once more, do you have any other issues
And I will
to
tell
raise?
you once more, I
with-
don't understand the questions that you are asking.
Sir,
So
do you
I
have
would-
any other issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
He has now
I don't
twice
understand.
not answered the question. I'll ask one last time and specifically advise him that his failure to answer the question will be taken by this court as a no. Sir, do you have any
what law of
additional?
fact? Under what law of fact can you say no? when I'm
Sir,
telling
do you
I
have
don't
any
understand?
additional issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
All right, he
I
has
don't
chosen
understand.
not to answer other than by saying he does not understand the questions. He did not specifically answer with a yes or no. Therefore, this court takes that as he does not have any additional issues
That
to
is-
raise with
that is
respect
incorrect.
to the
That is
verdict
incorrect.
forms.
That is incorrect. I stated I don't understand. You can't force me to understand something, Your Honor.
All right, did the state have any
It is-
other?
it is my
I'm going to mute him
constitutional right.
momentarily.
It's
Mr.
my
Brooks, I'm muting you
constitutional
because
right.
I'm moving on to another topic. I understand you disagree with the court's rulings, but you need to respect the rulings with proper etiquette in this courtroom, which you are demonstrating once again you're not willing to follow, so I exercised my ability to press mute. Does the state have any other requests as it relates to the jury instructions? I want to kind of full circle back to that because I do need to approve of them.
We do not.
Right,
Back
Mr.
to
Brooks, I'll ask you
life.
the same
Back
question. I
to
will unmute. Do you have any
reality.
additional requests as it relates to the jury instructions?
Yeah, I have questions related to all of them because I don't understand any of this.
My question was not, do you have questions, but do
And
you
my
have any
answer
requests?
was, I don't understand. And I've made several requests.
The requests are not related to the jury instructions, which is the phase of this hearing that this court is attempting to conduct with you and give you the opportunity to fully participate. Mr. Brooks is choosing not to answer my questions. I'm going to mute him momentarily, sir. I will ask you one more time if you have any requests as it relates to the jury instructions. I then will ask you if you approve of the jury instructions. If you do not answer those questions as it relates to the question, do you have any request as relate to jury instructions, I will interpret that as a no. And if you do not specifically answer the question about the jury instructions, I will interpret that as your approval. So first question to you is, do you have any, and you're unmuted, do you have any requests at this point as it relates to the jury instructions?
And I just said before, I said I do. I said I don't understand the questions. Of course I have questions if I don't understand.
Sir, do you have any
That's common
requests
sense.
for any additional instructions that are
Yeah,
not included, or to remove any that are included?
Yeah, remove them all until I understand, or add the jury instructions that I have myself.
What jury instructions do you have, sir?
So now you don't know I had jury instructions, and I told you this weeks ago.
Oh, shut the fuck up.
What filing are you referring to, sir? If I've overlooked that, I will certainly reconsider, but I'm not
You
aware of a
overlook-
specific jury instruction.
It seems like you overlook a lot, Your Honor.
Can you point me to a specific filing?
So you have all my filings on file? Are you saying that you have my filings and they haven't been admitted into evidence?
Oh, my computer's not working.
Oh, now the computer's not working.
Sir, please direct me to the specific filing that you're referring to that has a request related to jury instructions.
Back to reality.
You just said you was referring to the filings, right? Did you just say that?
That's not what I said.
That's not what she said,
Did
dickhead.
you just say what filings are referring to jury instructions? Did you or did you not just say that?
I
She
said,
did not
do you
say
have
that.
a specific filing you can refer the court to that relates to jury instructions?
So is your computer working or is it not working?
Is your mouth working or is that not working?
I
It's
think
gotta
it's
be
not
soon.
Temperamental, but I have,
Bubba's counting
I just
on
can't
it.
use my search function. So if you can direct me to a filing, that would be great.
It would also be great for those filings to be admitted into evidence.
Sir, simply filing something with the court does not make it evidence during the evidentiary phase of a trial. There are rules of procedure and rules of evidence that govern that.
And you told me to make all my filings in writing.
Sir, I said if you had a motion, it needed to be put in
All those
writing.
were motions. All those were motions.
Sir, what filing are you referring the court to?
Look through all my motions.
Sir, it's not my job to advocate on your behalf. If you have something in
I didn't ask you to advocate
particular,
on my behalf.
Sir-
I asked you to do your job.
Did he just say he wants Bubba to advocate on his ass?
How about this? I don't accept none of those jury instructions. I don't accept any of them. Any of them. And again, I'll tell you, I don't understand. Why do I have to keep saying this when it's clear that I don't understand?
Your Honor, I can inform the court that jury instructions were due, I believe, on August 30th. The state submitted their proposed jury instructions as well as the substantive instructions, and the defense indicated that they agreed with our filing. So I don't believe that there's ever been a request for any different jury instructions than what have been filed.
Peggy. No, you're not muted. We all see your duplicate comments over and over and over again. No, I'm just kidding. You're good, Peggy. We see you. I see you, Peggy. What's the green box at the top of the screen? So that's the daily goal. I'll start doing this when I live stream, and we've definitely surpassed it. So I'm going to set a daily goal of $400 because that's essentially what it cost me to run the show all day. And if we reach that daily goal, I'll do a night show. Not in this voice, but I'll do a night show. Yeah, so I'll see you guys at 8. We are doing a night show tonight. Fuck yeah.
that he does not have any additional requests.
I didn't say that.
And they will be
I said I don't
approved.
understand.
They will be
You
approved
can't-
and are,
No.
I'm going to have to mute
No.
him. They are approved as been drafted by the court and modified during the jury instruction conference on the record this morning and this afternoon. I will once again review all of them just for grammar, just to make sure all of that is correct.
I'll do the whole
And,
night show.
provide
Wait.
a written
I'll do the whole night show in this voice for $1,000.
parties before we break for the day today. I am also approving of the verdict forms that have been previously submitted to the parties, just noting there's just a few grammatical things that need to be corrected, but the content and substance are there, and I've already addressed on the record any requests by the parties this afternoon.
No, Your Honor, I believe that the final copy that we've been working off of is appropriate.
Any comment about that, Mr. Brooks, or any statement?
I don't consent to being called that name, and I've just told you I don't understand these jury questions. I'm not going to know how are they allowed to pass just because you feel that they should, when I'm telling you I don't understand them.
I would note that
One of those jury instructions came from me, not one. How's that fair?
Mr. Brooks, this court gave you the draft of the jury instructions. I need to mute you because, once again, he's debating about things that I think are very clear on the record. This court provided both the state and Mr. Brooks with a written printout, 107 pages long, of the jury instructions it was considering in this case. We had a discussion this morning. We continued that discussion this afternoon. Prior to breaking for the lunch hour, all of the verdict forms were printed off and provided to both the state and to Mr. Brooks. It is also true that when he was previously represented by counsel, the court had some specific deadlines related to jury instruction proposals, and the state reminded me that there essentially was not an objection raised regarding the proposal and the filing from the state. I had a brief opportunity to look through the record of the inmate communication forms that have been sent during this trial that are on file. I haven't seen anything that references jury instructions. I'm well aware that he has other filings, but I could not find anything related to jury instructions and any specific requests that he is making or made during this case. So for the record, I am approving of the verdicts. I am approving of the jury instructions. And once again, before we break for the day, I will make sure to provide the parties with written printouts of both of the documents as they now stand. Then there are a few other issues we need to go through. Attorney Basie, I think you brought these up prior to the break. Maybe it was Attorney Opper, in terms of scheduling and what I would consider other housekeeping issues, but go ahead and remind me once again of the issues you wanted to bring up. I think it was the alternate sequestration, and there might have been a third.
Yes, Your Honor. The question is to the sequestration of the jurors once they are excused for deliberations, and should the timing require that, an overnight stay or something along those lines. We wanted to discuss that. We wanted to discuss what the court intended to do with the three alternates once they have been selected. It would be our request and position that they should remain in a secure location, separate and apart from anyone else, unless and until full deliberations are complete by the 12 selected to decide the case, so that if needed and in light of the brief COVID history we have on this record, if needed, one of the alternates could slide into position of one of the
Could
12 who are
slide.
deliberating if that became necessary. So we wanted to address that, and then we just wanted to address timing generally for closing arguments, verdict returned by the jury, and then the court's intentions as to the rest of the week, should there be guilty verdicts returned.
Sure. Before I address all of those, are there any of those final type of issues, sir, that you would want the court to address? You have been unmuted, so you can answer that. Mr. Brooks, do you have any of those final type of questions or issues that you want the court to address? You are unmuted. I am.
I just told you since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're gonna be based on whatever I'll base them on.
Well, I trust the state will object when appropriate,
Well,
if appropriate.
It's gonna be a whole lot of objection then, because I'm gonna tell the truth. You haven't allowed. You just been making all the decisions for me, even though you know I told you repeatedly that I don't understand, and you still make decisions based on my behalf without my consent, without me. I'm telling you I don't understand, and you still make a decision determining my life.
Are you telling me, sir, that you will refuse to follow the simple rules of decorum, courtesy, civility, the rules of evidence, and the rules of procedure?
Don't try to come with your slick words, and don't put words in my mouth.
Sir, I am not being slick. I'm trying to preserve the integrity.
You've been slick. You've been slick.
All right. I'm going to mute you, sir, since what you are saying is not productive. It is not courteous. It is disrespectful. I need to go over these. All right, I'm muting him because I need to go over these important issues that have been raised by the state. So as far as the alternates, I do think it is important to keep the alternates who in a secure location, even if that means an overnight, unless and until verdicts are reached in this matter, and I will so instruct the clerk of courts to make those arrangements. We have been doing that all along in any event. As far as selecting the alternates, obviously each of our jurors have a number. I intend to have pieces of equal size pieces of paper made, folded up with each of their numbers, put them in the same turnstile bin that we utilized for the selection of jury preemptory strikes by lot, and to simply pull out 3 names. Those will be the alternates, and then or I should say not names, the numbers, and then the numbers that are remaining would be those 12 who will deliberate. And so I'll make sure that that's out here for the appropriate time. As I indicated this morning, all of the jurors were provided with some information regarding sequestration. It is the practice of that I've approved in this case that the jurors provide us with certain emergency contact information so that we are able to get a hold of families should there be the need. They're given information regarding sequestration, the purpose of it. If I have not made that a part of the record, I will make sure to get a copy of that filed in this case so that both sides know what was provided to the jurors today before they left. And then I'll also make sure that when the 12 are deliberating, that the 3 who are not are taken to a different jury room with a bailiff, and again, kept in a secure location, but separate from the other 12. In the event one would be needed, we would then take up that issue at that time, but I think it's good practice to have them available if that becomes an issue. As far as timing, I'll first address, I've instructed the jurors to be back at 9 a.m. That's because typically we have a few things to finalize in the morning, so we'll start at 8:30 tomorrow morning. It will also give the parties one final opportunity to read through the many, many pages of jury instructions and verdict forms to just make sure there aren't any other issues that jump off the page or that need to be addressed first thing tomorrow morning. But then I do intend to start with instructing the jury. This case will require a very lengthy time of the court reading off the jury instructions. I do believe it will require me to take some regular breaks, probably every 2 hours, until the jury instructions are read, with perhaps a longer break at the lunch hour. And my best guess is that it'll take between 5 and 6 hours to fully instruct the jury. That's based on the 107 pages. Now, some of those pages, though, are after argument. And so that really kind of begs the question is, will the parties get to their closing arguments tomorrow, or will that be done Wednesday morning? I certainly would like to have the parties make their arguments. Madam Clerk, may I see the instructions that we have thus far? The packet? I just...
It should be done and printed.
Okay, thank you.
Single side.
So the instructions that I read prior to the parties giving their closing arguments finishes on page 73. So given that, I believe that the parties will be able to give their closing arguments tomorrow. It just may be, depending on where that takes us, whether the final instructions are given the following morning, because that's another 30 pages. I'd like to be able to do it. It just really depends on how late of an evening. I'm not opposed to going late, but letting the jurors go to the hotel and then starting their deliberations in the morning if that's what needs to be done.
Understood, and we'll be ready. I think from our recollection, it took you about 2.5 hours to read the preliminary instructions, which was 69 pages in length. So if that holds, I think, we reasonably could do closings in the afternoon, and it'd probably take you about an hour or hour and a half to read those remaining 30 pages. And we may still be able to wrap up by 4 or 5 o'clock in the courtroom.
I think that's a reasonable time frame. Do you have any estimation on the length of your closing? I'm contemplating maybe putting a time restriction for both parties. I mean, we had a solid 15 days of testimony, so I'm mindful that this is not a 30-minute closing.
Well, actually, I'm trying to keep it in the 30 to 45-minute range, just out of courtesy to the jury, and to highlight the important points.
Do you think it would be reasonable to give the parties each an hour total? That would reserve whatever's left from your initial for any rebuttal?
Yes.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying book. I'm looking at the Bible. Thank you. It's not just a book. It's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by it, though? Anyway,
Dude, he fucking
Sir, I'm
killed 6
contemplating
people.
putting
Oh
an
my
hour
gosh.
time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm not doing it tomorrow.
Then you'll forfeit your right to give one, sir, because as we have,
You can't force me not. What type of court is this where you can say you're gonna force somebody not to be able to give a closing argument? How's that lawful
sir,
law?
if you choose
How
not
is
to
that
give
lawful law?
one,
How's that lawful law?
sir, if you choose not to give
Good.
one you're not letting me finish and you're mocking me right now, which is incredibly disrespectful once again.
Okay,
You didn't even let me get my sentence out.
You always want to make a incorrect record. Go ahead. Make your incorrect record. Go ahead.
I'll mute him once again because clearly he just wants to be disruptive this afternoon. But as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake. We will need a comfort break. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself and I'll have my clerk make sure we accurately time that. I will read the final instructions and I'll really leave it in the jury's hands. If they want to start deliberating, that's fine. If it's 7 o'clock at night, I'll probably tell them we're going to break for the night. They'll be sequestered, but they will come back and begin deliberations in the morning. That will be Wednesday morning. But now that I really kind of laid that out and thought about the break I will have for closing arguments with even my 107 pages, we can get this done tomorrow. And so that's my expectation. So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
Then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws if they don't agree.
You are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise. And you can't, so you added these jury instructions at the last minute, then you should have never approved them from the get-go because I never approved them. I told you I didn't understand them at all whatsoever, and you still passed it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear to me you've done your homework.
What you talking about? I don't care what you're talking about. I'm going to let them know that they can nullify any law they don't agree with, which is my right.
It is not your right to do that.
Say that it's not.
It is not your right to raise jury nullification.
Show me lawful law then. Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning. He may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here. and I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented. And those are the bounds. If he's going to, I can only imagine there may be some objections by the state. If there is an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure and the rules of evidence, then he will be in that other courtroom for his closing argument, so that I can exercise mute, frankly, to protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law. You do not have a right to talk about sympathy. That's very clear in the case law, whether it's evidence or arguments. The juries, if you read through the jury instructions, sir, you will see they are specifically told they will not be swayed by sympathy, by prejudice, or passion. They are not to be concerned themselves with any penalties. You can't argue penalties. You can't argue jury nullification. You can't argue legal issues that aren't relevant to the elements and the other law that's in these jury instructions. And those are the very clear rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the jury, or forfeit your right to be present in this courtroom and appear from the other courtroom. And you are squarely put on notice of that here today, sir. With that, I think I've addressed all of the issues the state has asked me to address. Oh, one other issue, verdict timing. I know we have some time on this. I realize that there are many, many victims who may still be watching the proceedings remotely. There may be news media, in fact, that may want to cover the verdicts, and that this jury will take some time due to the sheer volume of counts in this case. When this court is advised that verdicts have been reached, I am contemplating between 30 and 60 minutes before bringing everyone back into the courtroom for the verdicts to be read in open court. And if parties believe I need to wait longer, then let me know. But I think some of it will depend on is it late at night? Is it during the day? Are we dealing with any kind of traffic issues? I realize Mr. Brooks has family in Milwaukee area that may want to be here as well. Even if I consider the outlying areas of Waukesha, you could be as much as 30 minutes away. So that's my initial thought on that. Any statement from the state on that?
Not on that issue directly, sir. I'm sorry, Your Honor.
It's okay.
I apologize.
Any other issues?
Yes, my other issue as to verdicts was seating, if you intended to maintain the designated benches for the reasons you just said.
I would intend to keep the seating as is.
Okay, with the reserve.
The entire side behind the state for victims.
Okay, and the other side
Public.
reserved for the first 5 minutes, or is that open seating over there? Or do you wanna
My
think-
previous, or my rule throughout has been 15 minutes. What I would say is any open seating, we'll open the courtroom. It'll still be open the whole time because we're waiting, right? So it has to be. So any seat that's left open within 15 minutes, victims could also sit on the other side.
Okay.
If that's what you're asking me.
Yes.
All right. Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
So, again, I don't understand nothing you just said, but, I don't, how can you deprive me of my constitutional rights? How can you trample on my constitutional rights? How?
Sir, you can forfeit a number of constitutional rights by
Ah.
misconduct on your part.
Not if I reserve my rights, you can't let me reserve my rights and then take them from me.
Sir, I direct your attention to Chambers versus Mississippi,
I'm not
Rock
gonna
versus
hear none of that.
Arkansas, State
Yeah.
versus Anthony, Illinois
Did they
versus
reserve their
Allen,
rights? Did they reserve their rights?
the
Did
Beneby
any of those
decision. There's a host
Did
of
they-
case
did they-
law, sir.
Did they reserve their rights?
All right, sir, you are simply mistaken on that. So I'm muting him once again. He's not giving me any other issues to address. We are in recess.
Oh, I'm sorry, I had a few
Go
other.
ahead.
I'm
You
sorry.
do. I'm
Yeah.
sorry, go ahead.
I just wanted the record to reflect that at about 2:04 PM, your clerk had provided the final version of jury instructions to both the state and to the defense. I watched on video as Deputy Wittig left this courtroom, went over to the other courtroom, handed the final jury instructions to Mr. Brooks, and he immediately turned and dropped them to his left off the side of the table. I can't tell from the video if that's where the trash can is located or not, but I did see that immediate response after he was handed the final jury instructions. Another
Did that
thing.
include the verdicts or just the jury instructions?
Just the jury instructions, I'm still doing verdicts.
Okay, it's just the jury instructions, but thank you, because I didn't see that given some of the things I was looking at up here, so I appreciate that.
Were all jurors, or will all jurors then be told to report with an overnight bag?
That's part of the instructions that
Okay,
they were
and you're
given.
gonna make that available to us?
Yes,
Okay.
I'll get Lauren down here right away, and I'll make sure that before Mr. Brooks is taken back to the cell. I see your arms waving, I'll get you in a second, that he's provided with that as well.
All right.
And you as well.
And then one final thing as to timing, and again, I don't mean to be disrespectful to Mr. Brooks or anyone involved in this matter, but should there be any guilty verdicts in this case, would you be intending to proceed to sentencing yet this week or at a future time?
You know, that's an interesting question because I don't know how many victims will want to speak. If we have time, I would certainly consider that. I mean, I have this entire week set aside yet. And I have Monday morning, but I have some other things Monday afternoon, and then I am not available the rest of next week. So it really just depends on the timing. I would need to know from both the parties whether they anticipate anyone speaking other than the parties themselves. Any family members?
Yes,
I don't
we-
think I need a PSI. This is a trial. This is not like a guilty plea, so. Mr. Brooks, I'll get to you. I'm unmuting you. Go ahead. Go ahead. You're unmuted.
And since we're all making records to make me look bad, I think we should say for the record that one of the rights I have is to demand that the court places in evidence any unrevealed contract, statute, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to, sir?
I'm referring to my rights under the Sixth Amendment.
And what
My
case law
constitutional
says you
right
have a
under-
right to do exactly what you just said you have a right to do?
The Constitution, Amendment 6.
Sir, that is very general, your statement. It's vague. There's nothing
So we gonna go
specific
what?
you have
What
referenced.
You want paragraph 2 or something like that? Is that what you want?
No, that's not what I'm saying, sir. You're making
So,
general arguments
also-
that aren't based in fact and are overgeneralizations of what the law requires as well.
I accept for value and return for value any documents in this matter. Since, it might be another record of what I'm doing, since it's always a record of what I'm doing. And I also have the right to ask, is this common law or admiralty law? Because judging by the gold eagle on top of the flag, it's some explaining that needs to be done. And that is a military symbol. So is this a common law court or admiralty law court?
Mr. Brooks, I'm frankly not going to address these nonsense legal theories of yours. I'm muting you. They have been debunked. They are typical sovereign tactics that have no place in our judicial system. We are in recess. I'll see everyone tomorrow morning at 8:30. I'll just direct the bailiffs to wait until we have the verdict forms to give. And if it takes us longer than 30 minutes, we'll make sure they're delivered to him in his jail today. Thank you, everyone.
Thank you.
You know what? The one thing that I find kind of annoying, jury nullification. That's an interesting concept that I didn't realize that you're not allowed to tell the jury. I had no idea about that. Jury nullification is interesting. That whole idea. There's no audio coming. I still have the live feed on, but they have him muted. They should unmute him now. I want to hear what he's saying. That would be dope, right? As he's yelling. But they're done. But I'll leave this on until the feed cuts out. Jury nullification is interesting because what jury nullification means and what he said he was going to do is he was going to tell the jury that they could, even though he may be guilty of the crime, they could find him not guilty of said crime. That's jury nullification. It's where a jury knows that the person is guilty, but decides based on religion or whatever the fact that they're not going to convict him for whatever reason, right? I didn't know you couldn't tell a jury that. I didn't even know that, like, if someone is talking about that in a jury room, that they can get in trouble. I had no idea about any of that because I always thought that the way our justice system works is that you would be able to, well, no, because I guess with the jury instructions, you have to find the person guilty if they, again, this goes back to what he's charged with, intentional homicide or whatever his initial charges are. Because again, based on the evidence that's been provided thus far, I think we may, oh God, I'd hate to say that, but I think that there could, here, I'll say it this way. If I was on the jury, I wouldn't be able I couldn't say that he deliberately, well, I can't say that he intended to kill those people. And based on the specific verbiage of that particular charge that he's being charged under, they have to prove that he intended to kill those people based on that charge. That's why I said last week, I don't know why they didn't charge him with first degree reckless homicide, which is still 60 to life, I believe, or 60-year maximum. I don't know why he wasn't charged with that, because then they don't have to prove intent. They don't have to prove that he was deliberately trying to kill people. Because here's the difference. You could say that he knew that there was a likelihood that someone would die if they're hit by a vehicle, right? Because that's common sense. But the actual, when you look it up on the Wisconsin state legislature website, it specifically states that he intended to kill them, not injure. That's why he's charged with 61 counts of reckless. And see, that's the thing that's perplexing too. He's charged with 61 counts of like first degree reckless endangerment or something like that, but not even the charge of like first degree intentional maiming or whatever the equivalent would be for his first degree murder charge. Do you know what I mean? Which is interesting to me. Someone said intent is when he went in past the barricades. Yeah, maybe we'll learn something. Because I'll be honest, when we were playing the jury instructions in the first place, when they spent the 2.5 hours going over the court cases, hold on, I'm waiting for a delivery, so I got to make sure this isn't it. Hello. No, you have the wrong number, sir. Like to call about your car insurance warranty. But yeah, it's interesting to me. Steve, when the testimony of one of the victims said they saw the car barreling down the street, going left and right and back to the left, that's intentional. That he is swerving all over the road, which shows the intent was not the intention to hit people in the parade. That's where they all show. What? That he was not, or the intention. I don't understand your comment. Again, I don't have it open right now. I don't, and his rap song was not about him. His rap song was not about him taking out old people with his vehicle. That's not true. He did, however, have social media posts where he was, saying that he was going to assault old white people, but that wasn't his rap video. I think his rap video was talking about like drugs and shit, the cool shit, what all those kids talk about nowadays. I don't know. It's interesting because I missed the jury instruction in the beginning, so I don't know what. I don't know. I could swear that they said he would have had to intended to do it. And that's why they had, with Kyle Rittenhouse, same state, he was charged as well with this same thing. First degree intentional, or, first degree murder with intent or something like that. What? I don't know what the fuck he's talking about. He assumed they would get out of the way. Yeah, again, I watched the video too. So the fucker's guilty as shit. But I look at the law in a specific way, probably flawed, but you know what I mean? I follow it just like anything else, like when you're reading a book. Right. Well, now reading a book's not a good analogy because you could still get your own impression of what was happening based on watch first degree. What was it? Here, let's not lose this page because that page was interesting. Oh, you guys want to see if Karine Jean-Pierre is live yet? She's probably late. Karine Jean-Pierre.
Any ballot cast or affected the accuracy of voter registration information. Any attempts tracked by FBI have remained localized and were blocked or successfully mitigated with minimal or no disruption to election process. That said, we will continue, as I said, monitor any threats to our elections if they arise and work as a cohesive, coherent interagency to get relevant information to the election officials and workers on the ground. Okay.
Thank you. You just mentioned that 22 million people have applied to have their student loans forgiven. They are expecting to have some or all of their debt cleared. You called it game-changing. How confident is the White House in your authority to actually clear this debt? And do you have any concern that you may be giving millions of Americans false hope?
Look, the president was very clear that what he was trying to do. He was trying to make sure that we gave middle-class Americans who are feeling a tight squeeze, especially coming out of dealing with this pandemic, an opportunity to be able to take away the student debt that really holds people down, if you think about it, in order to start a family, in order to put money down on a house. And so the president's going to do everything that he can to make sure that we get this done. Again, I mentioned 22 million people have signed up, but this could help up to 40 million people. This is what this can do. Give almost 40 million people an opportunity. 90% of them make less than $75,000. That is a big deal. That is a game changer. So we're going to continue to work and make sure that people continue to apply. And I'll leave the legal process over to our counsel's office and the DOJ actually. And but again, it's not going to stop our message. We know that there are our opponents out there who don't want us to help middle-class Americans, but it's not going to stop us.
And this legal fight could drag out for some time. Is there any chance that the president is considering extending the pause on federal student loan payments, which are set to expire in January, or is that off the table?
Look, I'm not going to get into hypotheticals. We have to let the process play out and see where the where the process goes. So we're not going to get ahead of ourselves from here. It is a temporary order, right? So just want to make sure, don't want to get ahead of any of this. It does not reverse the fact that a lower court, the court dismissed the case. Let's not forget that, or suggest that the case has any merit at all. As I was saying at the top of the briefing, we will continue to move full speed ahead in our preparations in compliance with this order, of course, and we'll continue to urge bars to apply at studentaid.gov. But again, we're not going to get ahead of it. It's a temporary order, and so we're just going to let the process play out.
Is that even on the table, considering extending
I
it?
don't have anything to announce if anything's on the table on extending the pause. What I can say, it's a temporary order, and we are going to do everything that we can to continue to do our outreach and make sure that people apply. But again, it's a temporary order. It does not. It's not. It is. It doesn't suggest that it has any merit. And so again, we're just going to continue moving straight ahead.
Green, over the weekend, the Chinese president won a third term. What does this mean for U.S.-Chinese relations, and will they meet at the G20 as well?
So I don't have any, to take your first question last, your last question first, sorry. Don't have any meetings or anything to preview to you at this time with the president or the president of China. But we, as we have said many times, we're not going to comment on internal party politics of the PRC. President Biden and our administration are focused on responsibly managing our competition with China while cooperating on areas where our and the world's interests align, which is important to us, from climate change to health security. We continue our efforts to keep lines of communication open, including at the leader level, as we have. We've had about 5 calls with President Xi, as we have announced to all of you in the past 20 months. As you've seen, President Biden has spoken to Xi, again, as I've said several times, and we believe it is important to keep those conversations ongoing, and we will continue to do that. As far as a meeting at the G20, don't have anything to share at this time.
And just to follow up, today the U.S. Justice Department says 4 Chinese nationals, including 3 intelligence officials, are charged in a spy recruitment campaign. Is there any reaction from the White House to this?
Again, DOJ has a standard process, as I've mentioned many times, for notification of law enforcement actions, and I can check to see if there's anything else that we can share for you at this moment with their announcement today, just moments ago. I would refer you to the Department of DOJ.
Thanks, Green. The results of the National Assessment of Educational Progress are in, and they show serious setbacks in math and reading for 4th and 8th graders. The government mobilized the whole of government effort, and including legislation, to respond to the economic consequences of the coronavirus pandemic. Are there any plans to mount a similarly widespread, wide-ranging, and comprehensive effort to respond to the educational consequences of this pandemic?
So, as you all know, from when the president walked into this administration, it was a top priority for him to safely reopen schools, and he did that, especially for our kids, right, across the country, millions of kids. And let's not forget, when he walked into this administration, the COVID response was incredibly mismanaged by the former administration, and he understood just because it was mismanaged, that action could not come at the expense of our children. So he said he'd get to work, and the first step was reopening schools, which he did. It was about 46% of schools were open, and in a short period of time, we were able to open schools fully in just a few months after the president walked into the administration. Look, we understand, as Secretary Cardona said this morning, the results of this data are unacceptable. That is something that the president believes, and you heard directly from Secretary Cardona today. So we always knew that getting schools open would not be enough. That's why it was the first thing that we had to do. A once-in-a-generation virus has had profound impacts on our students, as we've seen from the data. And thankfully, the American Rescue Plan, to your point, that was a government approach to make sure that it provided essential funds to help students catch up academically and address the pandemic's impact on their mental health. And let's not forget that the American Rescue Plan was something only Democrats voted for. no congressional Republicans voted for that piece of legislation, which was critical to getting our economy back up, including opening up schools. So we're focused on ensuring schools across the country to use the American Rescue Plan funds to help students recover. And we have already launched nationwide efforts to get students recovered with efforts we know that work, to hire more high-quality educators and expand tutoring, summer and after-school programs bolstered by these very, very funds that the first major piece of legislation that this president was able to pass when he walked into the administration.
And then the president said last week that he's gotten 16 to 18 requests to campaign in these closing weeks. But other than a trip to Pennsylvania, he's got no campaign travel scheduled for this week. So I'm wondering, with 2 weeks to go, does the president feel like he's doing everything he possibly can to get Democrats across the finish line in these midterm elections?
So look, you just heard the president just moments ago at the DNC. Of course, I have to be careful of what I say because we do respect the Hatch Act here in this administration. Look, when the president speaks, he has a large bully pulpit, and he has been able in the past several weeks to set that national conversation, right? To be able to talk about what's at stake, what the choices that the American people have to kind of decide on, if you will. And he's talked about student debt relief. He's talked about the economy. He's talked about infrastructure. He's talked about abortion, what it means to make sure that women have to be able to make a decision on their health, right? Abortion rights. And so almost every day, you have seen the president in front of the American people talking exactly to that, what is at stake. And let's not forget, we are actually laying out issues and policies that are very popular with the American people, that are issues that the American people want to see when you think about lowering cost. And you have congressional Republicans who want to take that away, who do not want to see Americans have lower health care costs, who do not want to see Americans have lower energy costs. The first thing that they said that they would do is repeal the Inflation Reduction Act, which, by the way, pieces of that, if you look at it in its parts, every part of that is popular with the American people.
But as it relates to travel, are there any plans for the president to ramp up his travel? I mean, we have just
I'm not going to get ahead of the president. There will be more travel that we certainly will be announcing, as you mentioned. He's going to go to Pennsylvania this week. We announced that he's going to be doing the DNC. I shouldn't say we. The DNC announced that he's going to be doing a rally on November 1st in Florida, and I would say stay tuned.
With the Israeli president coming for a visit, it comes at a time when there has been a notable uptick in some prominent anti-Semitism and some questions about how Republicans are responding to that, how the culture is responding to that. What is the president's view of how that might even influence the visit or be a subject of the visit, or how he believes the country should be responding to that? Kanye West has been a part of it. Others have been asked to respond to the corporate side of those sort of notable instances.
So I could just speak for the president and how he feels, and he feels that our administration and himself should respond to this. Let's not forget, the president ran on healing the soul of our nation, right? After years of years of division, years of hatred. And so he's been very clear on that and how important it is to make sure that he does that in this administration. So when racism or anti-Semitism rears its ugly head, he is going to call it out. And he has called it out. We should not allow that conversation to be existing, not just in the political discourse, but in our everyday lives. And so that is something that we're going to continue to call out, that the president's going to call out. It is ugly, it is dangerous, it is despicable, and he believes that that we should as leaders in the political party, leaders. It doesn't matter if you're which side of the aisle that you sit in, we should be calling this out. And that is something that, again, he's going to condemn, and he's going to be very, very clear to call this out in the strongest terms.
Does he think others have been timid in that area?
I've talked about this before when we saw the situation in Los Angeles, and I was asked about the city council members specifically in Los Angeles, and they were Democrats. And we were very clear, it doesn't matter if there's a D or an R after your name, that we should call this out. And what is sad about this is you see Republicans in Congress who make these horrific, and not just in Congress, but across the spectrum, make these really vile and despicable comments about racism and anti-Semitism, and they don't call it out. And that is not going to be how the president is going to handle situations like this. He is going to call it out regardless of what side of the aisle you sit on, regardless of, again, if there's a D or an R after your name. There is no place at all
She said
for
D.
that type of vile,
She said D.
belief
She
or
meant
language in our political
dictation.
discourse. Go ahead, Jackie.
Thanks. On student loan forgiveness. Okay, sorry.
No, it's okay. It's hard. It's hard.
Student loans. If the legal challenges are resolved, do you expect that anyone will get their loans forgiven before the midterms?
No.
Before. Look, we're not doing this. That's not our goal
Yes,
here.
you are.
Is to get this done before the midterms.
Yes, it is.
That's not something. Just want to make sure clear that up. We want to make
Lies.
sure that we give American borrowers who are able to get this benefit of this program, the president's program, relief as soon as possible. Clearly, there is this case before us, and so what we're going to do is continue to do outreach to make sure folks apply online and to make sure that they know if they are eligible to get this relief. Again, this is not about for this president. This is not about the midterms. This is a campaign promise that he has kept. This is another way to make sure that we are giving Americans a little bit more of a breathing room. This is another way, as we're dealing with high cost, Americans are dealing with high cost, that they have an opportunity in this regard with student debt relief to give, again, a little bit more of space to breathe and a little bit more opportunity to get things done for their families.
And very quickly, we saw the First Lady in a Phillies t-shirt yesterday. Should we expect that they're going to go to the World Series?
I don't have anything to announce, but as you know, the First Lady is very excited about her team going into the World Series. I don't have any scheduling to announce. I don't know. I don't have anything to share at this time, but clearly there is some excitement in the Biden household. Go ahead, Jackie.
Thanks, Corinne. Today, the president seemed to be countering some of this GOP messaging on the economy, and he told people that Republicans like to call Democrats big spenders, and people should look at the facts. But the facts don't seem to be exactly how he's painting it on some of these issues. He has claimed repeatedly that the administration reduced the deficit, but if you break it down, spending was high because of the pandemic, those programs expired, and that brought down the deficit, and then that deficit reduction was spent on canceling student loans, and then on the jobs claims that he made. He said that President Trump was the first since Hoover to lose jobs during his administration, but and he claimed that he had created 10 million new jobs, but in reality, those jobs have mostly been added back, and the Bureau of Labor Statistics says only about 514,000 jobs have been newly created. So how are people supposed to take this kind of messaging on their most important issue seriously when some of this feels like smoke and mirrors?
Well, let me tell you what the American people should take very, very seriously. Let me remind you of the Trump tax cut of 2017, $2 trillion that was not paid for, So I want to be very clear about that. And let me also remind the American people of what was happening in January of 2020, January 20th or 21 of 2020, 2021, which was that American businesses, small businesses were shutting down. I just talked about schools. Only 46% of schools were shut down. There was not a real comprehensive COVID response and making sure that people got shots in their arms. And because of the American Rescue Plan, which is something that Republicans refused to work on, refused to vote on, the American Rescue Plan got those schools open, got those small businesses open again, and really made us and put us in a place where the economy turned back on. And we saw historic, I mean, don't listen to us, you're giving me data, but there's also data that shows that unemployment is the lowest that it's been in 50 years. It also shows that what we were able to do, even with the strong labor market, that was because of the plan, the economic policies that the president put forth. So he put in the work. And here's the thing, and I'll add more, and I'm happy to hear your next question. Congressional Republicans have been very, very clear on what they want to do. And this is the choice that the president talks about that Americans have to decide on, they have to make. They have said that the first thing that they're going to repeal is the Inflation Reduction Act, which actually lowers costs for American people. They have said that if they are not able to put Medicare and Social Security on the chopping blocks, right, they're going to essentially hold us hostage. If that doesn't happen, they're going to shut down the government. That does not that does not help inflation, that makes it worse. That does not help the economy, that makes it worse. And so that is the stark difference here of what we are talking about what congressional Democrats and this president want to do.
So why doesn't he lean more on some of that language than continuing to repeat this, we reduce the deficit thing that feels like sort of irrelevant?
No, the reduce the deficit is real. $1.4 trillion, that's what he talked about just last week, and that is historic as well. In 1 year, that's what the president has been able to do. Those are real numbers that matter as we talk about inflation, as we talk about the economy.
It just happened on its own.
No, but it is actually the policies that he has taken that has helped reduce the deficit. Let's not forget Trump 2017 with the $2 trillion that Republicans were very happy to vote on and was not paid for. So there is a difference here in how we approach the economy, how we approach what Americans are going through right now, how we approach dealing with middle-class families that you are not seeing currently. You're not seeing currently from Republicans. I got to move on because we don't have a lot of space. What? No, wait. Go ahead.
Ukraine. So as the president talked about his economic policies on Friday and today in the context of the midterms, he said he thought there would be a shift for the Democrats. Can you provide any clarity about what he meant by shift? Shift from what to what?
So I want to also be very careful here in talking about elections or politics. Look, there's going to be many polls in the short term that we have left in these next couple of weeks. I'm not going to get ahead of them. And as we know, polls go up, polls go down. It's a roller coaster. And so I don't want to get ahead of that. I'll just let his words stand because, again, he was talking about the midterm, so I don't want to dive too much into it. But again, there's going to be a lot of movement in the next couple of weeks, and I think that's what he was speaking to.
Okay, I have a question about the war as well. Secretary Blinken has already said that the U.S. believes that Russia's claims that Ukraine is preparing to use a dirty bomb are false claims. Does the U.S. have any reason to believe that the accusations are a signal that Russia is preparing a false flag attack?
So let me just get on the record on a couple of things, basically just kind of reiterating what the Secretary said. We reject Russia's transparently false allegation that Ukraine is preparing to use a dirty bomb on its own territory. Just today, you saw Foreign Minister Kuleba of Ukraine put out a statement about his call with Director General of the International Atomic Energy Agency, IAEA. Foreign Minister officially invited the IAEA to send experts to study the peaceful facilities in Ukraine, countering Russia's false claims. The IAEA has agreed to do so. We welcome this commitment to transparency and the assurance it will provide the international community. The world will see through any Russian attempt to use this allegation as pretext or for escalation. So obviously, to your question, Weijia, and welcome back. I'm so sorry. I should have said welcome back. Welcome back, and congratulations to you and your growing family. But obviously, we are concerned about the false allegation being used as a pretext for further escalation. And we've made clear we reject these allegations. And so we have not seen any reason to adjust our own, for example, nuclear posture, nor do we have indication that Russia is preparing to use nuclear weapons. But obviously, we are going to condemn what we're hearing and call it out.
Thanks, Corinne. Late Friday, the Department of Homeland Security released the latest numbers on border interactions with the Border Patrol. They show that over the course of fiscal year 2022, 2.4 million encounters happened on the southern border. That's the most ever on record. Republicans have their arguments about that. What's the White House's explanation as to what happened and why?
So I've said this before at this podium in the briefing room. What we're seeing, this new migration challenge, is driven by people who are fleeing falling regimes and economic collapse, as you know, in Venezuela, Nicaragua, and also Cuba. It's impacting the entire Western Hemisphere, what we're seeing currently. The number of individuals arriving from Venezuela, Nicaragua, and Cuba was up 245% from September of last year. Okay, there you go. As you know, we love charts. And meanwhile, the number of migrants from Mexico and northern Central America is down nearly a quarter compared to just last year. So we're seeing, again, a different challenge ahead of us that we're dealing with. But and we've talked about this. While we're trying to deal with the challenges, as you all know, you have Republican governors who are using these migrants, using these folks who are trying to flee communism, falling regimes, and economic collapses, as I just mentioned. They're using them as a political pawn, which you've heard us call out many times from here, and you've heard the president call out. We are hard at work in driving toward a regional solution to manage this new challenge. As you have heard from us on October 12th, we announced, the Department of Homeland Security announced a series of actions with Mexico to provide an orderly and limited way for Venezuelan nationals to arrive in the United States and encourage them to stop putting their lives in the hands of smugglers. So since the launch of this joint enforcement actions, we have seen the number of Venezuelans attempting to cross the southern border decrease sharply by more than 85%. So we are doing the work every day to make sure that we deal with what we're seeing in the southern border.
Thank you, Corinne. I've got two questions for you. Earlier today, the Wall Street Journal reported citing people inside the Saudi government, essentially saying that Saudi Crown Prince Mohammed bin Salman regularly mocks the president in private, making fun of his gaffes and questioning his mental acuity. The reporter also noted that MBS preferred former President Trump to President Biden, and I wondered if you had any reaction to that.
I don't have any comments to that.
I've got another question about the economic message that we've been hearing from the president. He obviously has talked about the stark choice that the country faces between allowing Democrats to remain in power and putting Republicans in power. He's talked about how Republicans will crash the economy, they'll shut down the government, go after Medicare, Social Security. It's a pretty stark choice that he's laid out. And I wonder if this president, who's talked about how he can work across the aisle, work in a bipartisan manner, work with Republicans, believes that if we get to a point of divided government, if it's just going to be chaos, or if he actually thinks that things could actually work between a Democratic president and a Republican Congress.
So let me say something about your first question. I'm not going to comment about, kind of ridiculous statements. I'm not going to comment on that. But I'll be very clear. The president has been very clear from the beginning of this administration that we needed to review our relationship with Saudi Arabia. And so that is something that we are going to continue to review. And once we have something to share, we certainly share that. The decisions that OPEC Plus made recently, we saw it as them aligning with Russia. And that is going to hurt many economies across the globe. And so, the president is going to have more to say on that. And when he does, you'll hear directly from him. On your I'm not going to give it any more light. I'm just saying that more broadly. And on your second question, look, it's not, don't take my word from it, what they're going to do to the economy. The congressional Republicans have been very, very clear. They have said that they want to put Medicare and Social Security on the chopping blocks. They have said that. That is their plan. And if they do that, that is going to hurt Americans. And if they don't get that, they said that they would shut down the government. That is what Republicans have said. They also have said that they were going to repeal Inflation Reduction Act. Again, that's going to, if they do that, it will take away the power that Medicare has to negotiate, that they now have to negotiate prices for seniors to lower those prescription drug prices. They would take that away in a time when middle-class families are dealing with inflation. They want to take that away. This is also a plan, as you know, that deals with climate change in a real way, and they want to take that away. So that's them. That is them saying that we are laying down the choice between congressional Democrats and congressional Republicans. Okay.
Is the president ruling out any budget cuts, including discretionary spending cuts, or just Social Security and Medicare?
I don't have anything else to share on any policy updates.
And then on deficit reduction, the fact that the White House is celebrating deficit reduction, to build on Jackie's question, does that mean the president thinks that the deficit should be reduced even further next year? Would more deficit reduction be economically good at this point?
So he's going to do everything that we can to continue to reduce the deficit. I don't have any number to share, but he's going to do everything that he possibly can.
Karine, back on the China meeting, I know you guys are still working through that and you don't want to weigh in on internal politics there, but can you say from your point of view, if this meeting is to occur, given what we've just seen play out in Beijing, what kind of goals do you have going into that, given that the Chinese leader seems to be doubling down on a lot of isolationist policies?
Again, I'm not going to get ahead of the president and what a meeting that could potentially happen or not happen and what the agenda would be. As you know, the president has talked to President Xi several times. We've given a readout of that conversation, of how the conversation has gone and what has been the agenda on those several conversations. I'm not going to get ahead of the president on this.
Can you just say right now, given following the Pelosi visit, China shut down a lot of channels of communication. Are you confident right now that you have enough channels open to actually plan this meeting and make sure that you convey exactly what you're trying to get out of it and hear the Chinese side?
Like I said, we continue our efforts to keep lines of communication open, including at the leader level. So that is something that we have been doing for some time now, and we're going to continue to make that happen.
One in Africa, Karine.
Thank you, Karine. Two questions. First, it's been tradition for presidents of both parties the day after the midterms to hold a news conference to talk about what the voters of America have decided the night before. Can you commit that the president will do that this time around?
I don't have anything to read out to you or to lay out on the schedule for the president post-election. I'm certainly not going to get ahead of him or ahead of any announcement that we're going to make.
And on another matter, earlier today, a group of 30 House liberals sent a letter to the White House urging the president to shift his strategy on the Ukraine war, saying that more direct negotiation, direct contact with Russia was needed. That's something the White House to this point has not done, being deferential to the Ukrainians. So my two questions on that were, does the White House plan to shift course? And secondly, is the White House concerned that there may be some fracturing here of Democratic support for the war effort?
So look, we've been very clear, nothing about Ukraine without Ukraine. Like, we've been very, very clear. Like, this is a decision that President Zelensky is going to have to make when it comes to any type of conversation with Russia, any type of negotiation. That is something that Ukrainians need to make. We will continue to support them as long as it takes. Again, this is, and I've said this many times, this is a war, an unprovoked war, a brutal war that President Putin has started, has created. He can end this war at any time. He can end it today if he wishes. And we are going to continue to support the brave Ukrainians who are fighting every day for their freedom and who are fighting every day for their sovereignty. Again, that is up to President Zelensky and the Ukrainian people.
Concerned, though, about this being the first time that a group of Democrats is questioning the White House's strategy?
So I have not seen this letter. I will say this, that we're certainly very thankful of the bipartisan support that we have seen over the past several months during this war from Congress, and we're going to continue to keep those lines of communications open and continue to have conversations with members of Congress. I don't have a direct response at this time to the letter.
Okay. Thanks, Corinne. 2 questions on COVID. Can you give us a preview of what the president's going to say in his remarks tomorrow when he gets his updated shot?
Yep. I do have something for you all for tomorrow. So for the president, it's important for him to publicly receive his updated COVID vaccine tomorrow. As you all know, it's the right time for him to get it after his infection this summer. And he wants to send a signal to the American people that the vaccine is safe, effective, widely available, and also free. Ahead of the winter, and as more subvariants arise, there is a real urgency to getting the updated vaccine right now, and you can expect him to make that point very clearly to all of you tomorrow. And fortunately, the vaccines we've invested in targeted BA.5 and will be effective against these types of subvariants that we see thus far. We'll have more detail to preview ahead of his shot and remarks, but what I can say is that we're continuing to see encouraging trends in vaccinations. For example, in the first 3 weeks, we saw about 7.5 million shots. In the last 3 weeks, we've seen almost 12 million. That's a nearly 60% increase. That's important progress, and we know numbers are higher after the weekend. The big administration focus is on reaching those at the highest risk, particularly our seniors, and there's good progress there. Half of shots have gone to seniors, and that means almost 10 million seniors, nearly 1 in 5 seniors, have already gotten their updated vaccine. We're doing outreach on the ground. We're using existing funds for targeted paid media and continue to push everyone with a platform to spread the word, which will be a portion of tomorrow's event as well.
Can I follow up on COVID?
Go ahead.
Thanks, Corinne. Going back to the president's meeting coming up this week with the president of Israel, can you give us some sense about what topics are on the agenda? What is the president's goal for this bilateral?
Well, the president is looking forward to hosting the president of Israel. I don't have anything specific to share on what's going to be on the agenda or what's going to be discussed. But again, he's looking forward to that meeting, and as we get closer, we'll share more to all of you for sure.
Thanks, Corinne. There've been some slightly conflicting reports about Elon Musk. On one side, there's been a report that he might be subject to some kind of national security review. There's been kind of trolling on Twitter, communicating with Medvedev on Twitter. So there's been a little bit of confusion about what his role is there. And on the other side, there's been reports that he's in discussions, or the government's in discussions with him about providing Starlink to Iran, or to the people protesting in Iran. So could you give an overview of what's the administration's dealings with Elon Musk, who's obviously not somebody, he's an important person.
No, I know there's a lot of interest in this. We've heard those reportings. Those reportings are not true, so we'll leave that there. The national security review, that is not true, and I really don't have more to say on that piece as well, on the Elon Musk and what he's choosing to do and not to do. I'm not going to say more from here.
Thank you. 2 questions. One on Britain, UK. What kind of relationship the president wants to have with the new British Prime Minister, and does the president think that the British democracy is in turmoil right now?
So, look, the United States and the United Kingdom are strong allies and have an enduring friendship, and that fact will never change. And so we know they will continue to be reliable partners on a range of issues, including holding Russia accountable for its aggression against Ukraine. And we will be working very closely, we believe, with the new prime minister.
One on Deepavali celebrations by the president this afternoon. When did the president has a strong relationship with the Indian Americans community. He has spoken about it in the past. Do you remember when the president celebrated Diwali for the first time, and when was that?
With whom? When was that? I don't have anything to share. As you know, when he was vice president, he would hold these receptions and events at the vice president residence. And so, but as far as how early that started, I don't have anything to share. We're happy to check in with folks.
If we can get
Yeah,
that.
happy to do that. Happy to do that.
On the event tomorrow with the vaccines, is the White House shifting at all in its ask for additional COVID funding now that this rollout has begun, sort of a reassessment of what may be needed? And to that point, is there any sort of light with Congress that you guys see on a way forward to get that funding before the midterms, after the midterms?
Well, we believe. We believe getting that additional funding is going to be critical.
Is it still at 22?
It's still the same at $22 billion, and we are going to continue to have those conversations with Congress. That has not ended. We're going to continue to make sure we get that additional funding. As we know, we made this a priority to make sure that this new vaccine, the bivalent, we had funding for that in going into the winter months because we understood how critical it was to make sure that people got vaccinated. But in doing so, as you all know, we had to really pull money away from from folks getting free tests. And so we've been very clear with Congress for the past several months on how critical it is to continue this funding, to have our front foot, if you will, on making sure that we have new vaccines and making sure that we have the continued treatment to offer that to people for free. And so we're going to continue to have those conversations again, keep those lines of communication open. We believe it's incredibly important. What we are doing right now, this campaign that we're doing for this bivalent vaccine, is for the winter months. And after that, there is no funding available, and so we have to make sure that that Congress acts. Congress needs to act on getting more funding for COVID.
Follow up on COVID.
Okay, I'll take one last one. Go ahead, Phil.
Thank you. There's reporting out of Forbes that TikTok's China-based parent company, ByteDance, plan to use the TikTok app to track the physical location of specific Americans. My question is, does the administration still believe that it's safe for Americans to use TikTok? And does the White House believe that TikTok presents a security threat to upcoming elections, given that they are partnering with organizations like the Federal Voting Assistance Program to provide information about elections?
So I'll say this, haven't seen those reportings, but I'll say this more broadly, that the president is concerned about the power large social media platforms have over our everyday lives, and has long argued that tech platforms must be held accountable for the harms that they cause. And so the president has been very consistent on that. And the president has long been a supporter of fundamental reforms to achieve that goal, including reforming Section 230. As you've heard us say many times, his stance on Section 230 is not new, and it's something he made clear on the campaign trail as one. This continues to be his position on that specific story. I can't comment from here. And so I'll leave it there as how he sees social media more broadly.
Well, then to follow up, I understand that there are these concerns about big tech and social media, but the TikTok and national security implications seem to be unique. And this isn't the first time that TikTok's ties to China have been scrutinized. I know the administration has made use of TikTok several times over the course of the last 2 years. Will the president and the White House continue to make use of this platform, given that there are serious red flags?
So again, let me talk to the National Security Council team on that specific report that you are laying out at this time, and then we'll respond.
Thank you,
all right, thanks everybody. I'll see you guys tomorrow.
Press conferences has led to misinformation or contributed to
I'll see you guys
misinformation.
tomorrow.
Well.
Anywho. All right. Well, I'm still waiting for UPS to come and pick up these boxes of cookies, so I can't really go anywhere. But I want to go home and eat dinner, and then I got to pay household bills at some point today. But I tried to get Quincy to come on the show tonight. He may still, there's like a 10% chance he'll come on the show, but he does a show at 9 o'clock, I guess, and he's going to have a guest on. So he needs to get ready.
Good afternoon, everybody.
He needs to get ready for that guest.
So as the
Shut up. So yeah, I'm gonna do a show, and that's the way I'm gonna do it from now on. If you guys want a night show where we just kind of talk about all the news and headlines and all that stuff, I will put up the daily streaming goal, and if we reach that goal every day, because kind of what I was thinking, at least until I open up the coffee shop, with the new system and how I'm doing certain things around here, works pretty good, and I should be able to live stream certain things during the day. And essentially just keep one live stream up. I don't know if I'll run it on the main YouTube channel or even the main Facebook channel. Maybe I'll just run it on the Citizen Stringer ones, or I'll make a different different channel for those. But where I just kind of run kind of some of the news, but pre-recorded segments, different videos that I like, goofy stuff, just goofing around. Because I think if I can steer any of you away from watching mainstream media, then I'm doing my job. And yeah, because mainstream media, they're evil. But yeah, so tonight around 8 o'clock Eastern time, I'm going to be live with a full episode of The Rational American. We're going to talk about this attack yesterday in Eugene, Oregon, between Antifa and I'll say patriots in quotation marks. They were definitely patriotic people, but a lot of people, I don't like using that word anymore. What do you call them? Americans? Like Antifa versus America? That's pretty much what it was. So we'll talk about that. If any of you guys were there, because that's why I was trying to get Quincy on. And I know some of the other viewers were there. See, you could see, where is it? This thing? The sun is shining right through on the green screen and fucking it up. But that's, I moved my desk to the other side of the office, as you guys saw this morning when I did the walkthrough, because the AC and the heating duct is directly above. And so it just blows down right on me. It's very nice. But that right there, that thing is very distracting because it screws up my my green screen. And I could fix it with a curtain, but I'm not getting up right now. But yeah, someone said use cash wherever possible. It makes help small businesses too. Someone else said the CS app. Yeah, unfortunately, I'm rebuilding that, but it's just going to be like steveoatley.com. Which will have like the store. So the way we're doing this is, I wasn't joking when I said I was stepping away from, consuming the news as I was previously. I've had a lot of fun covering this trial over the past couple of weeks, and primarily just because the trial was nutty. You know what I mean? And that's why it's been entertaining for me. But it also served, to give me some time to like think about different things. I'm not going to go back to reporting the news the way I was. Obviously, we'll do a show which will have commentary, but I'm not going to sit here and obsess over headlines and figure out which news article to write and which news to try to do that. April's in charge of Citizen Stringer News. In fact, she owns it. The actual name, the website, it's hers, so I'm going to help her build a Citizen Stringer store so people can support that. From a business standpoint, just between you and I, it wasn't working. It was losing money every single month. Because again, news, we could do what everyone else does and go for the corporate advertising. In fact, we had those opportunities. We just didn't want to. We wanted to stay, individual. So what I'm doing now is just having fun. When I'm live streaming, it's having fun. And then I'm running the coffee business and building that out, getting the first store open finally. For the first of the year is the plan. And instead of just I haven't decided yet. Do I want to go like full on coffee shop, or do I just want to be like a kind of like, how wineries are like taste testing? Because I essentially just could make every single roast that we have there. We'll have the coffee for sale, but in the bags, but the actual coffees that you get in the hot cups, they'll be free. I want to just keep adding to it. So I want to give free lattes and cappuccinos and espressos and all that, free waters, stuff like that. And we'll probably open with coffee and water, and then we'll expand on even fountain drinks. Here's UPS. Fuck yeah, I get to go home. But yeah, so that's it. I'll be live tonight, 8 o'clock Eastern. If you haven't watched my evening show, please tune in. All right. It's something different. We'll see you live 8 p.m. tonight, Eastern time. As of CSTV, I'm rebuilding it. It's going to be a while. I'm kind of doing it at my leisure. No one should be getting billed for it anymore. And then we'll go. But yeah, UPS is here, so I got to run. We'll see you guys all tomorrow. Bye.